Members, Lordship.
Just. Yes,
Lordship, I beg to mention item number 36,
36.
part 2 hearing, Lordship. Part 2 hearing.
Part 2 hearing. Item
36. Lordship, sorry, 86, Lordship.
hmm?
86.
86.
Lordship, I've taken a concern if this matter can come up on Monday, Lordship, next week.
Monday.
Lordship, I have some difficulties today, Lordship.
You are for
AG, Lordship, Accountant General Office.
okay,
And for the petitioner, your lordship.
okay,
Fix item on Monday, Lordship.
okay. On the prayer of Mr.
And Mosaic.
and Moses, learned counsel appearing for respondent number
3, Lordship.
3,
No. 8.
8. Respondent number 8.
Yes, Lordship. 9, Lordship. My apologies. 9.
3, 8, 9.
Nine.
Respondent number 9.
Lordship.
List this matter on Monday was 11th.
11, Lordship.
11/9/2023. MS so and so learned counsel for the petitioner present.
Obliged, Lordship.
Thanks.
Your lordship.
Yes.
I'd like to mention item 79, lordship. On
Yes.
behalf of LT Santam, lordship. Lordship, if this matter can come up after 3 weeks, lordship.
Why?
Lordship, we have some,
What is there?
lordship,
Do you know this matter?
no, lordship, no, lordship.
It's 2017 matter.
Lordship, in that way, the matter-
Inclusion of ST of the state.
lordship. Lordship, in that way, the matter may come after 2 weeks, lordship. Since the leading counsel, he has some personal difficulty.
But I'm ready today.
No,
This court is ready to dismiss the matter. In view of the, where he is now, where he is? Is in the court
No.
premises?
no, lordship.
It's 2017 matter.
Or else, lordship, next week, lordship, next week.
We'll see next week,
Lordship,
2017 matter.
lordship.
On the prayer of Mr. B.G. Mobi, learned counsel, appearing on behalf of
The state respondent on behalf of LT Santam. For the state respondent.
LT Sanctum Learned Additional AG.
Lordship.
List this matter on next week.
Lordship.
List this matter after a week.
Lordship, I also like to mention item number 6 and 7, Lordship. It's an analogous matter, Lordship. Lordship, the affidavit is under preparation, Lordship. Lordship may please to grant 3 weeks time, Lordship.
No objection. Mr. B.G. Mobi, learned counsel. B.G. Mobi,
Lordship.
learned state counsel. Press for and granted 2 weeks time
Lordship.
for filing
3 weeks
counter,
time, Lordship.
3 weeks,
3 weeks,
3 weeks time to file for filing counter affidavit.
Lordship.
MS so and so, you are for petitioner
Yes, lordship.
present.
Lordship, I also like to mention item 70, Lordship. It's a bill application matter, Lordship.
17,
70. Lordship. Here, Lordship, I'm yet to receive instruction, Lordship. So, Lordship, may please grant every time, Lordship.
which for petitioner? On the prayer of learned public prosecutor, Mr. M. B.G. Mobi, list this matter after 2 weeks.
Lord.
May I please, your lordship,
Yes,
I will please to mention agreement item number 84 and 85, your lordship. Your lordship, for similar 84 and 85.
yes.
Your lordship, similar measure has been moved in the apex court, your lordship. And we are yet to get the SLP number. So your lordship, let the matter come up after 4 weeks.
But writ appeal is, judgment in the writ appeal is in your favor.
No, we are challenging your lordship. It's not in our favor. We are challenging it in the apex court. Minimum scale of the matter relates to minimum scale of pay, your lordship.
No, there is a judgment of this court, I mean, the division bench of this court,
Yes, your lordship.
which is in your favor,
Yeah.
state's favor.
No, your lordship, there's one judgment like with regard to minimum scale of pay, where it is not in our favor, and we have already gone to the apex court, your lordship. We are filing the apex court.
Objection.
No, your lordship, since it's pending in.
MS Libika,
Yes, your lordship.
Learned State Council submits that press for listing the matter after 3 weeks,
4 weeks, your lordship.
4 weeks. List of prayer not being opposed by MS Swenso, Learned Council for the petitioner. List this matter after 4 weeks. That it's of 2019.
Yes, your lordship. However, your lordship, we have already filed an SLP, your lordship, so. Your lordship, I also like to mention item number 33 and 34.
33 and 34.
Yes, your lordship. Your lordship, I am yet to receive instruction on the minimum limit responding, your lordship. I am pleaded responding number PhD as a responding, your lordship. However, they are yet to receive instruction here.
Any objection?
No, my lord.
Huh?
No objection.
MS Swenso, Learned State Council. Press for listing the matter after 2 weeks.
3 weeks, your
3
lordship.
weeks. List of Mr. Swenso, Learned Council for the petitioner. Has no objection to the prayer. Accordingly, prayer is allowed. List this matter after 3 weeks.
Lordship.
Yes, lordship.
My lord.
If more than pass earlier, it will continue.
Please, your lordship, I beg to mention item 47, your lordship. This matter may be listed after 2 weeks, your lordship.
47
47, your lordship.
on the prayer of Swenso, Learned State Council. List this matter after
2 weeks, your
2
lordship.
weeks. Mr. Swenso, Learned Council for the petitioner present.
Your lordship, I also beg to mention item 50 to 69. Here the pleadings are complete. So this may be listed for hearing, your lordship, in the hearing list, your lordship. 50 to 69.
50 to 69.
Yes, your
Who is
lordship.
the petitioner? Who is Joshua?
She's,
You are-
he is on leave, lordship.
Okay. So you have no objection.
No objection.
Then
Pleadings are complete.
applicants will list it for admission hearing.
Your lordship, right above this, item 48 and 49, these are analogous, but in these petitions, the petitioners are yet to file reply, so.
That's why we'll
In the meantime, it may be listed for hearing, and then in the meantime, they may be allowed to file the affidavit, your lordship. We've already filed our affidavit, lordship. No, in item 48 to 49, these are also.
prayer of the Learned Council for the parties list this matter for admission hearing after 3 weeks. All right. You are for respondent.
I'm for the petitioner, lordship, in item number 48 and 49.
That's right. 48 to 69.
Your lordship, 50 to 69, the pleadings are complete, but in 48 to 49, the pleadings are not complete.
So in the meantime, you complete whatever steps you have to take. So you list it after 3 weeks for admission hearing.
Yes, your
Lordship.
48 to 69.
yes, your lordship.
Okay.
Objection, lordship.
May I please, your lordship?
Yes.
My lord, I beg to mention item number 31.
Yes.
Here I've received the affidavit in reply filed by the petitioner just this morning only, so I need to go through the reply.
What?
So kindly let the matter release after a week.
You want to file a reply to
No,
the
no.
reply?
No, this morning only I've received the reply
Okay.
filed by the petitioner,
Mr.
E.T. Paphom.
You are for
State respondent.
learned state council submits that he has received a copy of the affidavit in April
Yes.
filed by the petitioner, for which he needs some time to go through. List of. Sometimes you go through. And therefore press for listing the matter after.
After a week, my lord, for admission hearing, my lord.
Mr. So-and-so, the learned counsel for the petitioner has no objection. List of prayer is list after a week.
My lord, again, I beg to mention item number 72.
Hmm.
My lord, just recently this matter has been entrusted to me. So I need time to go through the file. So kindly let the matter be set after 3 weeks, my lord.
72, 72
Yes, my lord.
on the prayer of
No,
Mr.
Mr. Lordship, I have a submission to make here. Here there are two IAs, Lordship.
Yes,
IA number 43 of 2023, Lordship. When this matter was listed last time, Lordship, that is on the 14th of August.
yes,
Lordship, this IA was heard,
yes,
Lordship, and then this is Kohima. He has disposed this IA, Lordship,
yes,
saying that the applicants cannot be allowed to delete their names from the petition, Lordship.
yes.
But however, when he verbally repeated the order saying that the IA has been disposed, not allowing the applicant to exit the petition, Lordship. However, it was not reflected in the order. So, Lordship, my prayer is if this matter can be listed in Justice K. Sama's court so that I may get a chance to rectify the order, Lordship.
No, it says your IA will be heard along with the main writ petition.
Lordship, there are two IAs, Lordship. The other IA is for maintainability. That can be heard with the main writ petition,
Which
Lordship.
one? Which one?
I'm talking
IA,
IA number 43, Lordship. There must have been a confusion, Lordship. This IA number 43 was disposed.
So
in the
we'll
last
have
petition.
mentioned before
Lordship,
court number 1. We'll adjourn it today
Lordship.
on the prayer of the learned counsel for the.
Lordship, no, Mr. Lordship. Lordship, I'm for respondent number 5. Kindly allow me 3 weeks time to file affidavit in reply to WPC 168 of 2022.
Hmm?
Allow me 3 weeks time to file affidavit in reply. I'm for respondent number 5.
Mr. So-and-so, learned counsel for respondent number 5.
Respondent.
Learned counsel appearing for respondent number 5. Press for 3 weeks time to file affidavit in opposition. Mr. So-and-so, learned counsel and
The senior for the petitioners. Lordship.
so-and-so for a learned counsel for the petitioner. Press for and granted 3 weeks time. List this matter after 3 weeks.
Lordship, if the interim may,
If there is anything,
Lordship,
you may mention.
Lordship.
I'm preparing for response number 6 to 15.
You record is 6 to 15.
Lordship, if the interim may be extended till then.
There's interim order.
Lordship,
Interim order was earlier itself continued.
much obliged.
Much obliged.
May I please worship?
Yes,
Back to motion, my lord, item number 28 and 29. Here I am for the petitioner, my lord. I pray that this matter may be listed next week, my lord.
review petition
Yes, my lord.
on the prayer of Mr. So-and-so, learned counsel to the petitioner. List this matter after 3 weeks. 3 weeks,
After a week, my lord, next week.
after a week.
Mr. Lordship, I beg to mention item number 4 and 5. If this can be listed on Monday, Lordship.
Why?
My senior is having some difficulties today, so Your Lordship. Your Lordship, in the meantime, I may be allowed to see the lower court records also. I may be allowed to go through, Your Lordship.
Lower court records, chief. MS Swenso, learned counsel for the petitioners. Item 4 and 5.
Yes, your lordship, point five.
Address that matter may be listed after 2 weeks. Mr.
And Longkumar, I'm for the private schools.
N.
Longkumar,
Lamkumar, learned counsel for the private respondent.
private schools.
Present. What about the government? Government, no one is appearing. Uses records and Angami. Learned state council. Present. List this matter after 2 weeks.
Now, your lordship, I also beg to mention item number 73. I have received the counter affidavit, your lordship. However, I will not be filing my reply, your lordship. So if this matter can be come up after 2 weeks.
MS Swenso, learned counsel for the petitioner. President. She would like to file affidavit in
No,
reply.
I will not like to file, your lordship.
Huh?
I will not be filing, your lordship. It may be fixed for admission hearing.
Okay, you are not filing.
Yes, your lordship.
Then why? For what? It's
For admission hearing,
hearing
yes, for
today.
admission hearing, your
It
lordship.
is listed for admission hearing today.
Your lordship,
What is
because
the difficulty? What is the ground of adjournment?
then it may be passed over, your lordship.
It's 73. Anyway, on the prayer of MS Swenso, learned counsel for this matter after 4 weeks.
Your lordship, that will be too long.
Hmm,
If it can be listed after 2 weeks or 1 week,
2 weeks.
lordship. Obliged, my lord.
That is your lordship.
Yes,
I beg to mention item number 88.
88.
I believe this matter may be listed after 2 weeks.
On the prayer of learned counsel for the petitioner. Petitioner,
Yes, your lordship.
this matter after 4 weeks, 3 weeks,
3 weeks.
3 weeks.
May it please your lordship, lordship, item 89, your lordship. May I pray this matter be listed after a week?
After a week,
Yes, your lordship.
after 2 weeks, on the prayer of Swenso, learned counsel for the petitioner. Petitioner,
For the respondents, state
Respondents.
respondents.
Please, your lordship. Your lordship, let this be the last chance.
Lordship. I've sought some clarification from lordship, so please.
after 2 weeks.
May I please, your lordship.
Yes,
Your lordship, I beg to mention item 83 on behalf of the counsel for the petitioner. Your lordship, if the matter be listed after 2 weeks.
on the prayer of petitioner.
Yes, your lordship.
MS Swenso, learned counsel petitioner. Press for and granted. 3 weeks time. List this matter after 3 weeks.
Yes, your lordship. Obliged. May I please, your lordship, I beg to mention for item number 87. Lordship, my senior is engaged in another court. Kindly list the matter after 1 week.
When?
After 1 week.
After 1 week. On
I
the
have
prayer.
a similar prayer with item number 89.
89,
Yes, lordship.
87 and 89.
Yes, lordship.
After 2 weeks.
Okay. Much obliged.
May it please your lordship.
Yes,
Lordship, I beg to mention item 32.
32.
Lordship, yeah, we are yet to receive instructions, so can you grant us 2 weeks time?
You are for respondent.
Yes, Lordship.
You are
CGC, CGC.
Okay. On the prayer of MS Swenso, learned counsel for the Respondents Union of India. This matter after 3 weeks.
Yes, Lordship.
MS Swenso, learned counsel for the petitioner present. You are also
Respond number 2 and 3.
record his name.
Like,
Lordship, I beg to mention item 35 also.
35,
Lordship, we are yet to file our affidavit, so can you grant us 2 weeks time?
you are for,
Uh, For CJC.
you need a same order. For filing affidavit.
Lordship, I also beg to mention item 2 and 3. Lordship, here also we are yet to file our affidavit, so can you grant us 2 weeks time? Lordship?
The Union of India,
Yes, responding 6 and 7.
6 and 7. 3 weeks.
Yes,
For petitioner,
petitioner, your Lordship.
record on. You are for,
I'm for respondent 8 in WPC 50 and respondent 9 in WPC 204.
first finish.
Please, Lordship, I beg to mention item number 10 to 27. 10 to 27, Lordship, kindly grant 3 weeks time to file a reply to the affidavit filed by respondent number 5.
Affidavit reply.
Yes, your Lordship.
MS so and so learned counsel to the petitioner. Submits that she may be granted some time to file. Affidavit in reply to the affidavit in opposition filed with state respondents.
No, Lordship, respondent number 5, that is a Nagaland Lokayukta.
Affidavit, which affidavit?
To respondent number 5.
You are for respondent number 5.
Respondent number 5.
Okay.
We have already filed our.
Filed by the respondent number 5. This is regarding those allotment of
Yes, your Lordship, cancellation.
that
That's it.
depreciated
Appreciate like
government quarters.
government quarters. Right of orders were cancelled.
10 to
10 to 27.
27, yes.
Pleasure, Lord.
Obliged.
Please, my lord. Lordship, I beg to mention item number,
36 to
no, 74 and 75.
74, 75.
Yes. Reading is already completed, so Lordship, kindly visit for admission hearing on 12.
Yes, on the prayer of MS Judge Jimobi, learned counsel for the petitioner, list this matter
On 12, on 12, on 12,
after
Lordship.
2 weeks for admission. hearing.
Lordship, there is emergency in this case.
What emergency?
I want to take even this, others have been appointed. The 3 petitioners, the 3 petitioner in the IA, when the case was pending, their service was again terminated in spite of the interim order of this honorable court. And those who were selected through NPSC along with the petitioners, their appointment order has already been issued, except the 3 petitioners, Lordship.
If there is a violation of the court's order, you file a contempt.
That has already been stayed. I file, IA stay. Contempt means it will take a longer period again. So we file IA, in the IA, it has been stayed.
State.
Yes.
Then there is nothing urgent.
Yes,
If it is state,
if the, no, but the appointment has not been issued. It was withheld, whereas others' appointment order has been issued. The 3 petitioners result, after selection, their appointment has been withheld.
okay. Anyway, after 2 weeks,
Lordship, then after.
because
also-
next week, I think so many matters have been fixed.
Lordship,
After 2 weeks
Lordship.
for admission hearing, you record their name also.
Shall we give a fixed date, Lordship?
It's up to you.
No. So, you give a date, nothing.
I remember you said yesterday, next week you will not be here. You have some urgent.
No, I will be here, but
Your plan hasn't changed.
no, sir, Lordship, I have a very bulky case to be filed before the Honorable Court. So all my time are being consumed by that.
Don't file a bulky case, make it slim. Trim,
My lord,
precise.
my lord will see because it will come up before this honorable court since court number one cannot take up the matter.
That's what I'm saying. So we're scared of taking up the bulky cases. So make it slim, trim and precise. Next week.
Very
After 2
tiresome.
weeks, huh?
Uh, After 2 weeks, lordship, then can it be on?
Twenty-third, make it 23rd.
23rd is holiday.
23rd is what?
24th, Saturday.
Saturday.
Yes, yes. Then on 21st. 21st Thursday.
21st.
That's a fixed item.
Will not say admission. That's on that you may be busy also again.
Lordship,
Yes,
my lord, I beg to mention item 44 and 45.
yes.
I'm going to file my vakalatnama.
44 and 45. These are analogous with item
36
36.
to
46 to 40. Adel.
36 to 46.
You are for 45 and 44
44 and 45, my lord.
Okay. Any objections? It is analogous matter.
Lordship, I have to note since there are so many repetition, I have to note which respondent they are representing.
For all the private respondents.
So this, if we adjourn 44 and 45, this, it will start from 36 to 46.
In item 44 and 45.
What is the matter?
This is Lordship, backdoor appointment in police department, constables,
Very serious.
very serious one.
So in that case, we'll grant her some time to file counter affidavit. Item 44 and 45.
44 1.
MS so learned counsel for the learned counsel submits that she has an instruction to appear on behalf of the private respondents.
Yes, Your Lordship.
Mr.
In item 44 and 45, WPC 197.
Therefore, she needs some time to file counter affidavit.
Your lordship, I'm here to file my vakalatnama.
You file along with that. For which she need to file power with other necessary steps. Mr. Accordingly, she press for 3 weeks time.
4 weeks time.
4 weeks time. Mr. The prayer not being objected to by the learned MS Judge of the Learned Counsel petitioner. List this matter after the prayer is allowed. List this matter after 4 weeks. It should be along with item 36 to 46. Mr. So-and-so, Learned Counsel for the private respondents is not that important. It is you to take a call for government.
And for the home department.
Yes, home department. Have you filed
No, lordship, we have to file.
you within 4 weeks, you also filed?
Lordship will make an endeavor.
Lordship, especially for the respondent number, government respondent, that is department, they still have not filed. This was filed on 12/9/20.
That's why I
Not home department, but police department.
home department, police department is under the home department only.
There is some are.
So who is for police department?
No, Your Lordship. I'm just for respondent number 1.
Chief Secretary. You are also. It's a backdoor appointment, according to her.
Yes.
So be serious about it.
Lordship. Apply for.
His Lordship, Lordship, I beg to mention item number 1.
Yes,
Lordship, here, the case of the petitioner is before the cabinet for consideration, approval. So I pray that the matter may come up after 4 weeks in motion.
any objection?
No, your lordship.
No
But your
objection.
lordship, if the matter is pending since 2019, so if the exercise may be done expeditiously, your lordship.
No, we cannot direct the cabinet
Yes.
in a contempt matter.
My lord-
Either you objected or you agreed to her prayers, that's all.
Then your lordship, as per your lordship wisdom, then I have no objection.
MS Bishop Leonard additional lazy appearing for the alleged contempt submits that the matter is still pending before the state cabinet, for which she phrased for 4 weeks time. This the prayer not being opposed by the MS so and counsel to the petitioner. List this matter after 4 weeks.
Okay, much obliged.
Obliged.
We'll see after 4 weeks.
Please, Lordship. Lordship,
Yes.
I'd like to mention hearing item number 82 on behalf of my senior Mohd Jamir counsel for the appellant. Lordship,
82.
Yes, my lord. Lordship, my senior has some personal difficulties.
You are
For the appellant, my lord.
on behalf of Senti Agner or of Mohd
Mohd
Jamir?
Jamir.
Mr. So learned counsel appearing on behalf of Mr. Mohd Jamir, learned counsel to the appellant. Submits that his senior is indisposed, therefore press for listing the matter after 3 weeks.
Lordship, let the matter,
I'm the response. Here in it.
82.
7.
Lordship, let the matter be fixed on 12th of this month.
Well, we have fixed matters. After 3 weeks. Or after 2 weeks, after 2 weeks,
Lordship, after 3 weeks then.
after 3 weeks. Yes,
Lordship, I beg to mention hearing, not hearing, item number 30 also on behalf of my senior Mohd Jamir.
30,
Lordship,
30.
Lordship. Lordship, let the matter be fixed on 5th of October.
On the prayer of so is this matter on 05/10/20 October.
Give you a placement.
Eighteen nine, they have adjourned. 18/9 adjourned.
Your Lordship, we have already mentioned in.
Amendments.
Yeah, to be listed after 2 weeks. Your Lordship.
In favor. Forty-eight and 49. 48 and 49.
48 and 49, they have mentioned along with. They have mentioned along with 50.
Is it? It is. That too.
Something.
Which is. Yes,
Lordship, in this case, CD has come, wherein it has shown that the accused prima facie case is shown, Your Lordship. I may be allowed to place the CD before.
just let her argue. We'll dispose of the matter.
Yes, sir.
You argue the matter.
May I please, your lordship?
Yes.
This case has been falsely implicated against the accused, your lordship. It's a false implication.
Please use the mic.
The accused has been falsely implicated in this case, your lordship. Your lordship, on the second, 6th of 23, the alleged accused was arrested along with her husband and 2 other persons at her residence. Your lordship, during that time, the counterpart were seized, and then your lordship, during the statement that was given to the IO, both the husband and the wife told the IO that the wife is not involved. It was only during that time the wife came to know about the seized item, and then she was not aware that her husband was involved in such kind of activities, your lordship. Your lordship, and many times the wife has told the IO that she was not aware and that she doesn't know about this involvement, your lordship. She has become a victim of circumstances, and then it has caused harm to her, your lordship. Your lordship, she shared no blame in what her husband's wrongdoing, your lordship. And then moreover, your lordship, she is a mother of 2 children, 2 minor children, aged from 6 and then 8 respectively, your lordship. And then both of them are under the care of their grandparents, which are grandfather, your lordship. And it's been 3 months that the children and the mother has been apart. And then she has been in the jail for the past 2 months for no fault of her. And then which has caused grave injustice to her and to both children also. Your lordship, therefore, I come before you to kindly grant bail to the accused and then give her an opportunity to prove herself innocent, your lordship.
That's all.
Your lordship, yes, your lordship. Your lordship, indeed, I may be allowed to take you to the annexure D, page 17, your lordship.
Page 17.
Yes, lordship. This is the property search and seizure form. Here also, your lordship, the accused name is not reflected. It is only the name of Jasper Lahan, who is her husband. His name is reflected in here, your lordship. Your lordship, just to support my submission, your lordship, I may be allowed to give a judgment of the apex for the family, your lordship, which I've also reflected in my paragraph 10, your lordship.
Is it the case of NDPS?
Yes, lordship.
No, that
Yes,
the
lordship.
judgment you are relying on.
Yes, lordship. Your lordship, I may be allowed to read.
Para?
Para second. 4th line. Next
This-
page, your lordship.
This court.
Yes, your lordship, I may be allowed to read.
But in this case, the possession was from her husband,
Yes, Lordship.
and the police, they have arrested the petitioner with their children.
Yes, Lordship. Your
On
Lordship,
that context, the Honorable Supreme Court has said that
Your
the
Lordship,
police had not applied their mind, because there were minor children, they were also taken to custody.
but Your Lordship, even in this case also, the seized item was not found, not seized from the accused, Your Lordship. It was from
But
the
you were
husband,
traveling together
Your Lordship.
in a car.
No, they were not traveling, but they were at the resident with another two friends who have come to visit them. And then
Okay.
as they were at their place, there was
She's from your
Lordship.
house, your residence.
Yes, that's my
Contraband were
residence.
seized from your house.
Yes, my house, which I was not aware, Your Lordship. I was not aware that Such
From
item
which
were-
part of the house?
Your Lordship, it was not mentioned, but from their room, Your Lordship. The husband was hiding it in her room, their room, Your Lordship.
Their room,
Yes.
including your room.
Yes,
There is a difference.
but Your Lordship, here, I was not aware, Lordship. I have no clue that my
Your husband and
was-
wife
Yes, Lordship,
staying in
but,
the same rooms,
but Your
same
Lordship,
bedroom,
yes.
and it was seized from your bedroom. Bedroom,
Bed-
from the bedroom.
Not very sure. I'm so sorry on that part, Your Lordship. It
Huh?
was not mentioned. It was not mentioned that they say that it was from the room, not. It was from the room.
But
that's
from
what-
your house only.
Maybe, yeah, from the house, Your Lordship.
What
But
is
Your
the,
Lordship, but that doesn't mean that even if we are husband and wife, I may not be involved in all the wrongdoing that my husband is doing.
you may
Your
not be,
Lordship,
but you appears to have involved,
Your Lordship,
appears to be involved.
Lordship, the
Your
statement
Lordship.
says otherwise, Your Lordship.
Ah.
If I may, Your Lordship.
You just tell us. After that, we'll see.
The statement of the accused, Your Lordship.
Hmm.
On being examination, she stated that I was born and brought up from a native village, Kisimai. I had studied up to class 4 from government high school, Kisama, Manipur, and give up my studies as my parents could not support me due to financial problem. I got married to Jasper Lama in the year 2006 and have blessed with 2 sons. Presently, our family resides at house number 1235, Podumbuguri village, Chumukidima. My husband is a businessman by profession and travels from Dimapur to Imphal, Manipur frequently as we run a shop, Northeast items at Delhi, and the goods were purchased from Manipur and Nagaland that sent it to Delhi through flight courier. We also owned a vehicle Baleno number NL07CA 5143 that uses for hire. From the year end of 2022, my husband started sunflower business, which I objected, but I was later blinded by the profit comes from this business, and thus me too assisted him in this business, Your Lordship. So here, Your Lordship, the accused is knowingly carrying out the business, Your Lordship. I'm not aware that how my husband brought the substance sunflower and the amount he gave per soft case. I also don't have any idea by which amount he sells. I came to know Romy Jan, Your Lordship, here, this is another co-accused, through my husband, as he told me that he used to deliver the substance to Romy Jan to sell. I had accompanied my husband twice or thrice when my husband delivered sunflower to Romy Jan. Your Lordship, here sunflower refers to that heroin, Your Lordship. So on 25/20/23 at around 6 p.m. to 7 p.m., my husband told me to accompany him to deliver 40 soft cases of sunflower to Ramijan. So on our way, I had contacted Ramijan that we will be at Holy Cross Junction and asked her to come there. As discussed, we reached the spot and my husband took out the sunflower, which was packed in a white polythene bag and handed over to Ramijan by my husband as I was waiting him inside the car. After that, we went to our home, and after reaching the house, I was told by my husband that Ramijan was arrested by police and he had switched off the phone, which he had contacted to Ramijan, Your Lordship. After 1 week, my husband went to Imphal, Manipur to send goods to Delhi for our shop and returned back on 30/5/23. And he again brought some more soft cases of sunflower and kept in the house. On 2/6/2023, Mr. Moniko Pucho and Cecilia came to our house from Manipur to repair their vehicle and to purchase vegetables from Dimapur to sell at their village in Manipur. So I offer meals, and while taking rest, the police personnel raided our house and recovered 59 packets of suspected heroin of approximately 748 grams, Your Lordship. These are commercial quantity, Your Lordship, which was kept by my husband, and later we were brought to police station. So, Your Lordship, prima facie, Your Lordship, the accused is involved in committing an offense, Your Lordship. So granting of bail at this stage will not be in the public interest, Your Lordship. If I be allowed to raise the CP, Your Lordship.
Is there seizure memo is there?
Yes, Lordship, it is in,
Which
it's
page?
in my page 17. 17 annexure D, Your Lordship.
Sunflower is
It's an illegal drugs, Your Lordship.
this 161 statement.
Yes, under 161. So it's relevant, Your Lordship, in consideration of Your Lordship.
But Your Lordship, we cannot take all in what has been said in the statement, Your Lordship, when in the custody, Your Lordship, in front of the IO, Your Lordship.
But what else?
She was not
What
informed,
else this court will look into
Your Lordship,
at
that
this
she,
stage?
Your
Only
Lordship,
161 only.
but still, Your Lordship, we cannot. She was not in possession of the drugs, Your Lordship. She's just a mere victim of the circumstances, Your Lordship, and she's also willing to abide by whatever this court will direct her to do, Your Lordship. And then since she's a mother of 2 minors, she has been away from 2 children, Your Lordship. So kindly consider, Your Lordship, since the children are in need of their mother.
You were arrested along with your husband or on different dates?
No, Your Lordship, I was arrested along with my husband.
Ah, along with your husband.
Along with my husband and 2 other persons, Your Lordship.
Apart from this statement, anything else?
Your Lordship.
Anything else?
No, Your Lordship.
Can you find out she's from which particular place?
Your Lordship,
The contrabands were seized from which place?
from the premises of the
Premises,
residence, Your Lordship.
residence, or which particular
That particular, Your
person
Lordship,
of
I'll
the
have to,
house?
yes, I'll have to take inspection regarding that.
Hmm?
Regarding that, apart from the city, I didn't get any.
Suppose it has got relevancy because your husband and wife,
Yes, yes, Your Lordship.
if it is seized from the other places, other than the bedroom and other rooms of the house, residence, she may not know also.
Your Lordship, they are allowing, knowingly they are allowing it to carry.
No, that is the statement. That's why I'm asking. We need something more to
Lordship.
that.
Then in that case, Your Lordship, may give me some more time, Your Lordship. Maybe next week.
And whether the custodial interrogation is required
Lordship.
even after 30 days.
Okay.
I mean, 3 months. 3 months.
It's not yet. Not yet.
When you were arrested,
2nd July 23, 2nd July, it's been like 3 months.
you have not mentioned the date of arrest.
Your Lordship,
Date of arrest is where you have mentioned.
Your Lordship in para 2, Your Lordship. It was on the same day, the 2, paragraph 2. 2nd, 6/23.
That is 2nd June.
Yes, Your Lordship,
You said July.
Your Lordship. My apologies, Your Lordship.
Why it is called sunflower?
Your Lordship, I have no idea. The petitioner will have no idea.
Any please. It's a commercial quantity.
Yes, yes, commercial entity.
So this will attract section 37.
37 years, the records of 37 comes.
We'll fix it on Friday. You come up with there is judgment of the Supreme Court on section 37 NDPS Act. This is your judgment. Will consider since you have relied, but then we'd like to give you one more chance, specifically on the section 37, because this case was on section 21, which you have relied. The Supreme Court, section 21.
Yes, Lordship, even this area.
Your case is section 22C.
Oh, yes, Lordship.
And this will attract section 37, which normally the Supreme Court has said that first you have to be negative so far as bail is concerned. This court should believe that there is a reasonable reason to believe that you are not involved. But CD says you are involved.
Yes.
Possession, you might not, nothing has been seized from you, may not, but then involvement, because you said something, so it gives you a more handle to research on it. We'll fix it on Friday. You also come with us. You retain the CD? Keep it or you
Keep it, Your Lordship.
just keep it. Our MS so and so learned counsel for the applicant. And also her MS
S. Vere, PP.
learned public prosecutor for the state of Nagaland. We'll list this matter on 8/9/2023 for further hearing. If we dispose it of, we'll dismiss it. So we'll give you one more chance.
Your Lordship.
We'll revisit.
Nevertheless, Lordship.
Yes.
Lordship, in fact, I'm handicapped today because my name is reflected in the cost list. So this skipped my right. Why did not bring the record as? But to clarify certain things, Lordship,
Yes.
on the last occasion, an order was passed by this honorable court, whereby the petitioners were directed to furnish the particulars relating to the pending case before the apex court. Lordship, the order is dated 14/8/2023. Lord. Your Lordship, like kindness.
Yes,
Lordship, in this case, the petitioners were directed to furnish the details of the case pending before this Honorable Sovereign Court. Lordship, in fact, to clarify the matter, because this order was also passed in my absence, on that day also, my name was not reflected.
so we'll give you another chance. You find out as directed.
Yes, Lordship, that's what I'm saying, because, Lordship, what I want to clarify is that, in fact, it is the respondent who has filed an appeal against an order passed by.
Who is the respondent?
Lordship, nobody has come today. That's,
So today you are there. So you
Lordship, the matter, in the matter before the Supreme Court, we're another party.
who is the party?
Lordship,
Your colleague who is appearing? Anybody appearing?
earlier, one lady colleague was appearing on behalf of
You
the.
talk to him. What's the bar?
No, I'm open to that, Lordship. In fact, what I'm hearing is also there must have been some kind of a settlement. Lordship, may I bring in the meantime to grant me about a week's time so that I can consult my client at Garela.
We'll give you 3 weeks time. You find it out, and in the process, I'll not record it. You may have a courtesy to talk to your friend, colleague who is appearing for the respondent and find it out as directed by.
That
this.
may not be recorded, Lordship.
Because that I'll not record it, but then it's of 2014 matter.
Lordship,
This is something I don't know.
it was in fact adjourned at under prayer of the respondent because the file in a similar matter, they filed an appeal against the judgment of the Sikkim High Court.
You are for petitioner.
Lordship. My names will kindly be reflected in the future causes.
No, you give, this might be a reason, this may be because your name could not be reflected because it's not supported by CIS, is not it? You have a word with the registry, why this has not been reflected. All right. There's a,
Lordship,
this-
otherwise, while filing, I filed a Vagla.
no, maybe it's of 2014, the system has changed. You know that CIS, it has to be supported by CIS, otherwise it would not be reflected. You have a word with registry, what's the?
Lordship, I'll do that.
Okay. Mr.
Apok,
Apok Pongana,
yes.
learned constable, the petitioner submits the. Since his name was not reflected in the cause list, when this court was the order dated 14/8/2023 to comply with the order dated 13/5/2023 passed by this court for placing details of the case pending before the Honorable Supreme Court. He submits that he prays that he may be granted 3 weeks time to obtain the necessary instruction and also to ascertain the status of the case pending before the Honorable Supreme Court. Next page. In the interest of justice, the prayer of the learned counsel petitioner is allowed. Mr. Accordingly, the learned counsel for the petitioner is directed to obtain necessary instruction and to place to ascertain the status of the case, which is stated to be pending before the Honorable Apex Court. List this matter after
Lordship, that only problem will be, it will be the respondent who will have the details.
That's what I'm saying. First, you have a word with the registry so that your name can be reflected. Number two, because it was directed to be reflected last occasion also. There must be some technical issue.
All right.
Number two, you discuss with your colleague, which I'm not recording, and find it around.
All right.
What is return answer? You take press steps. You are appearing.
I'm appearing for respondent number 2.
Okay. So what should be done today?
The respondent to have made an appearance, appraised this matter may
Huh?
come up on a fixed date ownership.
Your lordship.
You want to file some counter affidavit,
Yes, your lordship.
objection or whatever.
Yes,
What you want to file?
your lordship may not be allowed to file my vakalat nama
You have
for
not.
now. Yes. I have not received the notice, so I came to know about the institution of this petition while going through the cause list, your lordship.
You have not been engaged as yet. You have instruction.
Yeah, I've been engaged. I have the vakalat number. It's just that I have not filed this yet.
Mr. So learned counsel for the petitioner. As a respond number 2, Mr. So learned counsel submits that he has an instruction to appear on behalf of the respond number 2. For which he pressed for some time to file his power. Mr. Prayer is allowed.
Lordship, appraised
List
this
is
matter may come
matter.
up on
After
5th of October, Lordship.
List this matter on 5th of
October, Lordship.
5/10/2023. Okay.
Oblige.
Oblige, Lord.
May I please, your lordship. My lord, as started by this honorable court, the respondent has considered the petitioner case, my lord. May I place the order, my lord?
You share to us. It has been complained.
Yes. Sir. So basing on this order, the matter may be closed, my lord.
My humble prayer is, Your Lordship, may kindly close off the meeting.
Huh?
My humble prayer is, Your Lordship, may kindly close the meeting.
Close the matter.
Yes, Lordship. The department has complied with the order dated
Okay.
24 March 2023. And the petitioner service has been regularized.
Heard MS so land counsel for the petitioners. Mr.
Itibapong,
E.T. Wapang, learned counsel for the respondents.
3, 4. Respond number 3 and 4.
3 and 4. Okay. 3 and 4. Before that, Mr. So learned state council appearing for respond number 1. Then so learned council for the Mr. So learned council for the by placing the this is letter.
Oh, next page, sir. Your
Next
Lordship.
page.
Complaint orders is in the next page. Okay.
By placing the order dated 18/8, no?
Yes,
18/8/2023. Was by the Director of Animal Husbandry and Veterinary Services, Nagaland, Kohima. Submits that the respondent authorities have complied with the order of this court dated
24/3/2023.
24/3/2023, passed in WPC
WPC 150
One-
of 2019.
115 of 2019.
115 of 2023. Listed. The learned consular petitioners has also submitted that it has been, the authorities have duly complied with the order of this court as referred to above. In view of the above, the contempt petition is closed. This contempt petition is stands closed.
Much obliged.
This one is the one they requested from BC. And still which for 1981. What is the truth? We'll take up this first.
Item number
1991.
80 and 80.
We'll see that later.
Lordship,
Yes.
The brief facts of the case is that the two petitioners, the one in 59 and the one in 62, WPC. Both of them appeared interview in 2009, which was conducted by the state respondents for mathematics teachers.
Same advertisement,
Yes, same
same
advertisement,
selection process.
same selection
Only
process,
the candidates are different, so there are two petitions.
two repetitions, yes.
So which one will take up first?
Your Lordship will take up 59,
59, yes.
59, yes.
Yes.
Lordship, I'll take your lordships through the annexures, your lordship, the advertisement, which is at annexure A, page 21.
Advertisement.
Advertisement, yes, your lordship. Here in this advertisement, at
Postgraduate teachers and primary teachers.
graduate teachers, non-gazetted, under number 1. All the criterias are laid down. I am in regard of,
Graduate teachers, non-gazetted.
yes, non-gazetted at C, your lord, the P is,
Mathematics, you are concerned about mathematics.
yes, I'm concerned about mathematics and at P, minimum qualification, I am concerned about this. 45% of marks with P8. This was a. Now,
Mathematics.
later on, I'll come to my submission that this 45% of marks with P8 was the horse rules. Your Lordship, the notifications.
Where it is?
That they had arbitrarily put this 45%, the percentage here.
University
It
is
is-
recording not less than 42% marks with B.Ed.
Yes.
Huh?
45, yes, 45% of marks with B.Ed. So the percentage of mark, your lordship, at a relevant point of time, when the interview was conducted. The relevant central government notification granting relaxation to the state government and also the notifications issued by the state did not prescribe any such marks.
45 marks In the selection process.
Yes, that was that was as per the advertisement.
Yes.
But at a relevant point of time, when the exams was conducted, the policy that was in place, central government, Union of India, as well as the state government, was that no such prescriptions were there. No minimum marks was prescribed. Now, secondly, with regard to mathematics, Your Lordship.
At the time of conducting the exams.
Yes, yes.
And after the issuance of the advertisement.
Yes. That is my position. My first case, I'll take Your Lordship through the records, Your Lordship. Secondly, with regard to mathematics.
Just wait.
Yes.
Minimum marks of 45%. Then
And secondly, with regard to mathematics, even the two petitioners, they have degrees in commerce, Your Lordship. They have degrees in commerce only, but here it is prescribed PSC with mathematics, physics, and chemistry. But subsequently, the government allowed because of paucity of applicants, they allowed the commerce graduates to also apply. So almost all the persons who were appointed after this interview, they were from the commerce background, Your Lordship.
dehouse the advertisement.
Yes. That was the position. So the petitioners.
Admittedly, you are commerce,
Yes, I am commerce, Your Lordship.
degree in
And
commerce.
Yes, I'll take Your Lordship to the,
Not BSc with mathematics, physics and chemistry.
no. But commerce students were allowed to appear and selections were done from among them at that relevant point of time, Your Lordship. Now, I'll take Your Lordship to the written results, Your Lordship. There were the petitioner in this case is from Woka. There were altogether 8 vacancies, Your Lordship. Woka, which is in the advertisement itself, annexure 1, if Your Lordship may go down. The one which is next to last, that is Woka. There were altogether 8 vacancies of
Which one?
Woka. If Your Lordship may go down in the annexure 1 to the advertisement and go down second last, Your Lordship. Annexure 1, second last.
District, where it provides the district,
District, yes, under the district, yes. Under
Woka
the
district.
District, Woka district, yes, Your Lordship. There were 8 posts of mathematics teachers. There were 8 posts. Your Lordship may see 1, 2, 3, 4, 5, 6, 7, 8. So I am concerned with number 3, Yenchuchu. This is the Yenchuchu is a village. Your Lordship.
No, I'm not getting it from where.
From the just below the advertisement, Your Lordship, just annexure 1.
56,
In that
57,
column.
serial number.
Yes,
Serial number 56, 57, 58. In the
yes. 56, 57, 58, 59. So all this can't fall under Woka district, Your Lordship. 8.
so you are concerned
Eight
about,
I am concerned with Yenchuchu, the number 3.
okay. Yes,
So I subsequently, after the interview, though I was not selected,
it was district wise.
district wise only.
The centralized advertisement
Yes,
the appointment and selection
and then
was
even the results were declared jointly, your lordship.
district-wise.
Yes, but district-wise,
But the
by the.
selection process was conducted centrally
Yes,
or district-wise.
it was. Yes, it was district-wise only.
No, this is advertisement shows that,
Yes, yes.
is there any,
Normally, these kind of though advertisements are made in this jointly, commonly by the Directorate of School Education, exams are conducted district-wise, your lordship. So exams were conducted.
exams in
District-wise.
district-wise separately? Though the advertisement is,
Yes, advertisement is common.
okay.
In the result, your lordship, in the written result. Written at annexure B1, this is the notification dated 29 January 2010. This is the
How many posts?
altogether 8 posts. in the
8
district.
posts
Yes,
for
8 posts,
mathematics.
mathematics.
You are not concerned about science and English,
No,
only
only
mathematics?
mathematics, because I applied for the post of
But
mathematics.
it's very strange when you have provided for BSc with mathematics, physics and chemistry.
Yes.
How do you commerce were allowed?
Your lordship, the relaxations. So subsequently, we were allowed to.
No,
Apply for the
relaxation
post
will
of-
not have, will have an effect on this quality of the education again. Commerce graduate,
Yes,
how can we expect a commerce graduate to teach
they
mathematics?
have.
Commerce with mathematics background, your lordship.
Is it?
Yes, your lordship, commerce with mathematics background.
Where is that? Is where bio Khazizan?
No corrigendum, your lordship, but subsequently we were,
How it was changed? When the basic qualification, the requirements was a BSc with mathematics, physics and chemistry. On what basis it was changed to commerce?
Your lordship, to that extent, do we have to seek instruction? How, your lordship, if the matter can be heard in the whole year, because your lordship, we are still in the inception only. Because here, what
But
happened is that,
we'll have
Yes.
to go
yes, your lordship,
cross the hurdles one by one.
no, your lordship, what happened is that the petitioner appeared. And he was unsuccessful, your lordship. The petitioner was unsuccessful.
Madan Lal.
Yes, your lordship. He was unsuccessful,
Madan Lal,
and after that,
State of Jammu and Kashmir.
he submitted an application, and the government was gracious to appoint him under Shura Siksa Abhinyan, your lordship. Now he is working under his scheme, and now taking that scheme, he is asking for regularization, taking back to this advertisement. Now by this advertisement, all person has been appointed, your lordship. Now can we come back again? He has appeared, have been unsuccessful. Can we come again and upset this advertisement, your lordship? The law does not permit that, your lordship.
Are you challenging the selection
Your
process?
lordship, advertisement also, your lordship.
your
Yeah.
lordship, my submission is that in the written days.
If
I
that,
was-
that's all you just submit, then we'll
Yes, I
go to
was,
the.
I was selected. In the written exam, I was at the top of the list, your lordship. Then what happened? When the final results were declared. In the post in which I am concerned, your lordship, in Chuchu, in that school, with regard to that school, it was declared that there was no candidate. There was no candidate, others were selected. So what happened? The petitioner approached this honorable court by way of a writ petition. Because subsequently again, after it was declared, since the vacancy was still there, I submitted an application for appointment. They appointed me against that same post, against which declaration was made in the result that there is no candidate. I was appointed against that. Then subsequent to my appointment, the department again selected me to undergo this PhD degree course. The order is clearly there. They selected me and sent me for PhD degree. I completed the PhD degree. Then I submitted a representation for regularization of my service. What happened was, since there was no reply, I approached this honorable court by way of a writ petition, which is WPC 131 of 2018. Now, when the writ petition was filed, the state respondents came forward saying that he could not be selected because he did not possess the 45% mark. At the time the exam was conducted. So I did not possess it. Then this honorable court directed that my case be, by dispose of the matter, directing that my case be considered by the department. The department, in pursuance of this honorable court's order, considered his case and said that he could not be, his case could not be considered because he did not have the minimum qualification. That was there.
Minimum
Yes, education. Qualifying marks. He did not have.
45%.
Yes, that was the only case they had.
So you have to, by this writ petition,
By this writ petition,
you are saying that at that point of relevant point of time,
Yes.
this 45% was
Was
done away.
yes.
Was
Was not there.
not there.
Yes. I
You
also,
could have,
I could have been considered, and now since I have been appointed, at least on ad hoc basis.
so you are not challenging the advertisement.
No, I am not challenging
Then
that.
advertisement says it's
Yes.
45%.
I have I have
Where
a.
is the order of doing away of that 45%? Is there any rules or something like that?
No, this honorable court, but the division bench has held that when the advertisements, when policy decisions are made against the existing rules, they are not, they are void. They cannot be applied. That decision, clearly I have it here, Your Lordship.
That
Now that I have served for so many years, at least my case for regularization should be considered. Now that is my only case.
No, that will be different, not based on the selection process in terms of the pursuant to the advertisement. Because the requirement was 45%. And you have not
Yes.
been selected because you did not obtain, you did not secure 45%.
No,
Reason of your rejection
But
was,
they allowed me to appear the exam. At
yes,
that point of time, they, without discrimination, without telling me that you are not eligible, they did not reject my application at that point of time, Your Lordship. They did not. They allowed me to appear the exam.
no, whether this 45%, not less than 45% of marks
Yes.
with BA.
Yes. Obviously, because they know that the rule is very clear that 45% marks is not a consideration. They
Is
allowed me to appear the exam.
45 marks is marks to be obtained during the course.
No.
University degree.
University degree, yes, 45%. So when I submitted my application, they accepted it, knowing that I do not have the necessary qualifying marks. They accepted my application. They did not reject it.
Have anybody been appointed without having 45% marks in degree?
Subsequently, now.
No, subsequently by this advertisement. Anybody been appointed
No, Your Lordship,
who doesn't have the 45%
no.
marks?
no,
Then
no. Your Lordship. But at that relevant point of time, my only case is that, yes, I didn't possess that, but at that relevant point of time, that 45% mark was not.
where it is submitted,
Your Lordship,
the policy decision.
yes, Your Lordship, I'll take Your Lordship to the. I'll take Your Lordship's attention to.
The authorities were gracious enough,
Your Lordship, I'll take Your Lordship to.
allow you to appear in the exam.
Page 41, Your Lordship,
Hmm.
page 41. This is the notification dated 4th January 2008. From the second on the recommendation of the State Level Education Committee, The Governor of Nagaland is pleased to notify herewith the policy on recruitment of teachers under the Department of School Education. The minimum educational qualification for the recruitment of teachers in elementary, secondary, and higher secondary schools are then elementary schools, number 1, pre-primary classes A and P, 10 plus 2.
You're concerned about
Then 2 primary classes, upper primary classes. 5 to 8, Your Lordship, graduate with PA.
huh?
Number 3, under elementary schools, Your Lordship. Upper
You
primary,
are concerned about which one?
the elementary schools, and then the third one, Roman 3, Your Lordship.
Upper primary, primary,
Yes, upper-
plus
upper
5
primary
to
plus
7.
5 to 8. Yes,
Eight.
8, yes.
Ah,
Graduate with PA only. No marks. No qualifying percentage of marks is given.
No,
Now,
it doesn't say that you cannot fix it.
no, Your Lordship, I'll take your Lordship to attachment of this, the division bench of this honorable court, which was passed
In the same
In-
case,
in a similar case in Manipur. In a similar case in Manipur, where the division
see,
bench has-
this is a policy decision. If it is says that there should not be any qualifying marks,
yes,
or the no requirement of percentage of marks obtained in the during the graduation or the degree course, the matter would have been different. It doesn't provide, but then they have the authority to provide
Your
something.
Lordship, I'll take your Lordship through the central government relaxation.
This is the
relaxation
central
to-
government.
No, this is based on the central government.
Forget about central government.
No,
Will not go there.
the central government.
Is this a post of the central government, state government post or? central
It's
government
a
post?
state government boss, Your Lordship, but the state government is found by the central government notification. It is clear, Your Lordship. It is very clear, Your Lordship. The state government also asked for relaxation from the permission from the central government. And accordingly, the central government has given this relaxation to the state government. Based on the central government relaxation given to the state, this policy was made.
Do you need to take the
Yes,
permission from the central government?
yes, even the judgment of the division bench, even the judgment of the division bench has held that. Yes. NCT, the National Council for Teacher Education is the one which prescribes all this. And all the states follow that. That is the position, Your Lordship. It is not that the state governments can make their own decisions. No. It is the NCT based on the education.
Is it specific on that you cannot provide the minimum marks obtained during the course, the degree course?
Your Lordship, at that point of time, what happened was the NCT had made a prescription earlier that these are the qualifications which are required. What happened was because we didn't have, the states didn't have the requisite number of such qualified teachers, they asked for central government relaxation. The central government granted relaxations to the states, and based on the relaxations granted by the central government, the states recruited teachers. Otherwise, without the consent of the central government, they cannot recruit the teachers. That is the position. When it comes to relaxation, they have to go by the central government guidelines.
What is your marks?
43, just below 45%. It's a fact.
I will expect teachers.
Yes.
The quality of the teachers having less than 45%.
Yes. And they have appointed me subsequently again to that vacancy. That is
Yes,
the position, Your Lordship. Subsequently, against that vacancy, they have.
so we'll ask them not to cancel your appointment, terminate you if you are not interested.
Your Lordship, it is not about not interested. I am serving, and they have also, upon evaluation of my service, sent me for further PA degree. Your Lordship, the government has selected me for,
They are so gracious. This
Your
government
Lordship,
is so gracious to you.
their graciousness is there because they need my service, Your Lordship. It is not about paying.
So that aspect will be different consideration. If you harping on this advertisement, we'll go by the advertisement. Unless you put to challenge. See, you know that these are the conditions of the advertisement. And you have applied, you have been allowed,
Yes, Your Lordship.
and the authority obviously go by the condition of the advertisement, terms and conditions of the advertisement. Wrongly or rightly. Now you just cannot turn around and say that, no, I've been disqualified
Your Lordship,
as per the terms of the advertisement, and you cannot challenge it.
the principle of,
Rightly,
yes, Your Lordship, the principle of law is that if an act is done in violation of statutory provisions,
statutory
then
rules.
it is non-existent law. It is void. It is void in itself.
But
That is the position.
but the policy or the notification or the executive instruction is not,
It has to be,
it has no the force of law.
it has to be subservient to the law in place.
Yes.
It has to be subservient.
It has to be
Yes,
statutory rules.
that is my.
It has to be
yes,
statutory rules,
Statutory law.
not just by executive instruction.
Yes, this is why I would like.
You saw that these instructions or notifications
Your
are
Lordship may,
statutory in nature.
yes,
You just saw me.
if your Lordship may allow me to take your Lordship to the judgment of this honorable.
No, not judgment. You just show me. First show me this. This notification 41.
Yes. This is based on the central government.
What is central?
That is Page 45, your Lordship.
Page 45. Is
Page
it
45.
statutory rules?
Yes. This is. Page 45, annexure L1.
Page 45.
Yes. This short title and commencement. These regulations may be called a National Council for Teacher Education. Determination of minimum qualifications for recruitment of teachers in schools, regulations 2001.
Yes.
Then
This is
your,
a relevant provision.
yes, now your Lordship. If I may take your Lordship to the next page, page 46 onwards in the table. The table is provided. Level, minimum academic and professional qualifications. So elementary A is primary. B in page 47 is upper primary, middle. Here the third one, graduate with Bachelor of Education, BA, or its equivalent. Your Lordship. So no marks are prescribed. Your Lordship.
Page, whatever is page 49.
Page 47. Page
49.
49 is 2010. That is after the interview was conducted, Your Lordship. This is the recent one. 23rd August. Here, percentage of mark has been prescribed, Your Lordship. So this notification was effective up to,
Where's the selection list?
yes,
Select list. Before that, this place 41,
yes. Your Lordship.
how do we find that this has been based on the NC, what do we call it?
This, Your Lordship will see here, from the very
NCT.
applicability. Your Lordship will see its applicability. Note, under the note, Your Lordship, 2, some of the states are having basic teachers training courses of 1 year duration only, while in some other states, students passing secondary level examinations are admitted to primary level teachers training courses, so on and so forth. Such states may, by 2005, conduct basic teachers training programs of a duration of not less than 2 years, with admission being open to senior secondary, intermediate pass certificates. In the meantime, candidates who have undergone basic teachers training courses of 1 year duration or were admitted to such training programs after passing secondary level examination only may be given employment in the concerned states only. So this applies throughout the country, Your Lordship. Yes, and 2, applicability at page 45, applicability.
Well, policy doesn't indicate that this is based on NCT.
But it is the NCT which governs, Your Lordship. It is a fact. The NCT, whatever notifications the NCT brings out, it is applicable to all the states. It is applicable to all the states.
So you need not mention it.
Yes, even here it is in the applicability, it is clearly laid down. These regulations shall be applicable for recruitment of teachers in all formal schools established, run or aided or recognized by central or state government.
Just come back after.
Fellows.
Yes,
Yes, Your Lordship.
select list.
The written result, Your Lordship, which is a notification dated 29 January 2010.
Page,
Page 22, annexure P1, it starts from annexure P1, page 22, and then page 23, Your Lordship. Here, 23A, the Woka max. If Your Lordship in the middle, Woka max, page 23, I have given a typed copy of the selected candidates, Your Lordship. The petitioner is at serial number 1,
page
page 23.
23.
Yes, I have also 23. In the Lordship, in the middle, the column, the middle column, the one on the top is Woka English, Woka Maths.
Huh?
The one in the middle column, Your Lordship, page 23. This is,
Yes, I'm in page 23.
yes, yes.
I don't find yours is which district?
Woka, W-O-K-H-A, Woka district.
Where it is?
23A, Your Lordship, I'm sorry. 23, yes.
That's right.
I'm. The middle column, Your Lordship.
Welcome, Maths.
Woka Maths, yes.
Ha.
The petitioner's name is at serial number 1.
Robin Azim.
Yes. He Robin is on.
Read petition 62, same district, different.
No, different. It is Longling district. Your Lordship.
Okay.
So this was.
This
This is the written result,
okay.
written test result.
E. Robin Azim.
Yes.
Yes.
Then annexure P2, page 24. This is the final declaration of result of graduate teachers, undergraduate teachers conducted on 8/1/2010.
Where is Woka?
So Your Lordship will come to the Woka in the last column in the middle. In the middle, Woka graduate, Lordship. Serial number 1, 2, 3, under 3, maths, under 3, the third one, under 3, in the 2 empty spaces where there are no serial numbers given, there maths is given, and then
No
no
candidate.
candidate, no candidate.
This is after the Viva.
Yes, after the Viva, after the Viva.
Declaration of result, graduates, and then graduate teachers. This serial number 2, what is the name of, this is the name of the school or name of the serial number 3?
Yes, serial number 3,
What is this?
Yinchocho,
Huh?
the name of the school. the name of the school is Vinchocho. The village name, and then they named the schools accordingly. GMS Vinchocho it should be.
No candidate.
GMS, no candidate.
Hmm.
Now, Your Lordship, subsequent to this, the appointment orders were issued. Your Lordship, since this is relevant, the stand of the state is that I was appointed under the SSA, but this interview was conducted under the SSA scheme only, Your Lordship. These are the successful candidates, page 25, annexure B3 onward. And just a sample, Your Lordship, if I may read, 3rd May 2010, on the
Is there any type copy?
No, Your Lordship, this is the,
Very difficult.
yes,
For this court. Though having 4 eyes.
I know, yes, Your Lordship. Very sorry.
Hmm.
On the recommendation of District Selection Board to the appointment against the sanctioned post of 5 graduate teachers under Deputy Inspector of Schools Longlin, created white EDS SSA CBA 009 2008 to dated 2010-09. Shri Michoy B.Com, son of Yingki, date of birth 29/11/88, as per HSLC admit card, permanent address Yongshoe Village, pin code dated so and so, district Longlin, is hereby appointed as GD at GMS Yongsan under the establishment of the Deputy Inspector of Schools Longlin in the scale of base so and so, plus all other allowances as are admissible under rules prescribed by the government of Nagaland from time to time. This has the approval of the government wide number. So
Why you are showing this?
this is the, because this will become relevant. They are saying that now I was appointed under another scheme. What they are saying is the government, the state is.
Is
saying
it
that
your, is
this
it
is
your,
the same, this is the same scheme under which the interview was conducted.
no, this is this your appointment?
No, Your Lordship, I am just showing a sample of the appointments orders that were issued after the interview was conducted.
Pursuant to the
Yes,
advertisement.
pursuant to the advertisement, these were selected candidates.
Hmm.
The scheme under which they were.
This is which subject?
This is mathematics only.
Mathematics in respect of Longling district.
Yes, and this is also a BCom. He is also BCom. Yes. So almost all those who appeared the exams, they were from the BCom background, Your Lordship. But whatever, they were selected. I'm just showing this sample as to how, as to whether I was appointed against that same post which was left vacant because there is, as per the result here, there was no candidate. I am not aggrieved by any of this, but I'm just showing a sample of the.
Can you,
So that, yes.
can you have this records? Apart from your grounds, forget the ground, we'll hear you, that is another issue.
Records, what records you mentioned?
Records of this selection process,
You
because you say no candidate. He has shown that he was qualified in the written examination. Is that
Your
it?
Lordship, that I have made it clear in my affidavit in opposition, Your Lordship, as to why we have declared no candidate, Your Lordship,
But
because we have made it clear in my affidavit.
it's okay.
And if the Lordship is not satisfied, then
Then
records can be called, Lordship.
will it be available now?
Your
As of
Lordship,
2010,
yeah, so that, I don't know, Your Lordship, I have to inquire, Your Lordship.
because if there's your statement or not, of course, we believe, but then it has to, something has to be supported with the documents. So normally we would like to see the records, how the
Lordship, I have-
process, how why
I
you are
have to-
saying so,
I
on
have
what
to s-
basis.
I have to seek instruction.
You have to say, no, you have to, if you are satisfied, it's okay.
Hmm.
If you are not satisfied by your statement or not,
Hmm.
we can go into the records also. Okay.
Mhm.
So according to you, this, the appointment of this person,
Yes,
is the post where this person has been appointed
No, no, no.
pursuant to the,
No, your lordship, what I'm saying is that the state respondents stand now is that at the relevant time, the interview was conducted, vacancies arose under the state government's own post creation schemes. But now, and all those candidates who were successful, they were appointed accordingly, but so it was under a different scheme. Now, in the case of the petitioner, since he was subsequently again on his application appointed, he was appointed under the SSA scheme. That is what they are saying. But the scheme under which the petitioner and even these candidates were appointed was post creation under the same scheme, under the SSA scheme. Your Honor.
maybe the same scheme, but it may be a permanent post, regular post they
Yes.
might have created. And you have been appointed in a contractual or
A top basis.
temporary post.
I am not contesting.
Maybe
Yes.
same
I
scheme.
was appointed under the same.
The post may be a permanent one or it's like.
Yes. Post was the same one, permanent one. And since it was still lying vacant, I submitted an application to consider my case. And so they considered my case and then they appointed me against that vacancy, which was.
The consequence will be if your writ petition is allowed. We'll have to direct that he ought to be appointed, he ought to have been selected because he was qualified
Yes,
and eligible.
yes,
That is one consequential
yes,
result.
yes,
But if you mix up this regularization, that cannot be. Your present appointment, the present post where you are working,
yes,
if you are asking for a regularization,
yes, Your Lordship.
in terms of the advertisement, that cannot be, that's not possible.
Your
It has a two way of dealing with the things.
And that is exactly the prayer of the petitioner.
That cannot be. Otherwise, because we have to have that. If you have to be appointed, we have to have that you are all along, you are eligible in all respect.
Yes,
Pursuant to the advertisement, you could
Yes.
not have been rejected on the basis of 45% marks.
yes,
That is another which you will look into all the
Yes.
selection process.
Yes.
But regularization will be
So my-
different
Your Lordship,
things to be considered.
Your Lordship
altogether.
will apply this honorable court will apply your
So let us not mix up
wisdom.
things.
wisdom.
That is your prayer.
My prayer is only.
Because you already have been appointed
My prayer is that.
as per the advertisement.
Yes,
However, you have been allowed to work on, subsequently you have been appointed on contractual whatever. I
yes,
mean,
so
temporary.
my prayer.
Yes, yes.
Yes,
Since I was eligible, your service should be regularized.
Yes,
I don't
that-
think that is permissible.
that is, my case is that not regularized, but regular appointment retrospectively from the date of initial appointment. That is my prayer. That is my prayer, Your Lordship. So it is not asking for
So we are not concerned about your present post.
the present post, against the present post, because that present post was advertised. It was left vacant because of the reasons which the state governments are saying that he did not possess a 45% mark. Subsequently.
So how you appointed when you are not eligible? I mean, qualified. to be appointed.
That is only the, that is.
That's why I'm saying the
Yes.
government was so gracious of you.
Your Lordship, that is only since they are the employer. The state employer knows, Your Lordship.
So your stand has to be either as per
Yes.
the selection process pursuant to the advertisement. Or you have to go for
Yes,
regularization of the present post.
yes.
It cannot
but
go,
my-
it
my-
cannot go together.
Yes, but Your Lordship may apply your mind to my prayer, Your Lordship, because my claim is that since I was eligible at that time and since the marks prescribed are none, cannot be applied. Automatically, since it is against the statutory provisions, it would have no effect at all. So basing on that, and since I have been subsequently appointed to the same vacancy, which was left vacant by the interview conducted, that my appointment be considered
Okay,
on
continue.
the basis of that.
Proceed.
That is my only case. Your Lordship.
So you show your appointment order? Where is your appointment
Your
order?
Lordship, I'll take your Lordship to the appointment which is annexed. Page 30. Twenty-nine is the government approval, Your Lordship. Annexure T. Page 29 is the government approval.
Yes,
Yes.
how you have been
And this
appointed?
is 30th May 2011. Approved for ad hoc appointment of graduate teachers, maths, Yon Jocho, under Deputy Inspector of Schools, Woka. Sir, I am directed to refer to the subject cited above and to convey the approval of the government for ad hoc appointment of Sri Robin Isong, BCom Honors, as graduate teacher maths at GMS Yon Jocho, under Deputy Inspector of Schools, Woka. Under the scheme of Sarva Shiksha Abhiyan, while this department post creation notification number EDS SSA CBA 009-2008-1 dated 2010-2009, subject to the following conditions. In accordance with the terms and conditions contained in government's notification number so and so dated 27-10-08, Sri Robin Isong shall give an undertaking that he will undergo the B.Ed courses within 2 years. If he fails to obtain the said professional qualification, his service will be terminated. Number B, the appointment shall be on ad hoc basis on a fixed monthly salary of rupees 8,400 only till such time regular appointment is made through the district selection board after he has obtained the professional qualification. During the period he undergoes the professional training, the vacancy post shall be filled through redeployment. Substitute appointment shall not be admissible. Formal appointment order may be issued from your end accordingly. The government approval number and date shall be quoted in the appointment order. A sample of the undertaking to be given by Sri Robin Isong is enclosed for reference. Lordship.
Read clause B again.
Yes, the appointment shall be on ad hoc basis on a fixed monthly salary of rupees 8,400. Subsequently, the petitioner approached this honorable court by way of another writ petition, and the direction was given to pay him the scale of pay. So he is now being paid the scale of pay, Your Lordship.
Till such time regular appointment is made through
Yes,
the
it was by
district
way of a
selection
different writ.
after he has obtained the professional qualification.
Whatever.
That's what I'm saying. Why this? We can say that the prayer of your regularization can be considered separately without, going into all harping on those advertisement, all other things, because you have accepted this ad hoc appointment, you have undergone B.Ed course.
Yes,
And it provides that one of the condition of your
Yes.
appointment approval is that you'll have to undergo the B.Ed course.
yes,
You have
I
undergone,
have undergone it.
and you will this is fixed pay till such regular appointment is made through the district so and so.
Yes,
After you obtain there's a scope of praying for regularization as per this
yes.
approval. So you go for request for regularization instead of harping on those.
No, I have requested and it has been turned down, Your Lordship. Because of that, I have been compelled to approach this honorable court.
By this writ petition.
Yes, by this.
Then
The second time.
why you are harping on those
In the earlier.
advertisement? Either will consider about the advertisement, how you have appointed, how you have been not selected. According to you are all eligible and in the horse the NCT and all, you have been disqualified. First, that one we may consider. So far as the regulation of the present post is concerned, there is a scope of looking into a matter.
Yes,
That will be another subject matter or the.
yes, but now, Your Lordship, one problem is.
So you first decide,
Yes.
are you harping on the advertisement or regularization?
No, I am.
If you have prayed
My
two prayers,
is that presently the new policy is that it is 50%. The percentage mark has been laid down under the new subsequent to the advertisements. Now, if that applies, I will not be again eligible to appear at district selection.
That is another issue that
That
we
is
not
a-
bring in all those which is not before this court. I think your prayer should be in consonance of the rights you are claiming.
Yes, your lordship.
You just cannot have the prayer. The variety of prayers you would like
Sir,
to make.
your lordship,
It
I
has to
humble-
have
yeah.
a basis of making a prayer before this court.
Yes, your lordship. So my humble submission, even in my prayer, is that my appointment should be, since I have already gone through the,
Either you should have been
Also-
appointed because you were eligible all along.
yes. So.
As per the advertisement and other
Yes,
things.
I would be
That
satisfied.
is one part of the looking at, I
Yes.
mean, deciding the matter. Another part is if you decide that matter, well and good. But suppose if we decide that the matter that you are not eligible, you could not have claim for all this, you have been rightly disqualified and all that.
Yes.
Then next, we cannot consider your regulation in terms of this present appointment. It has to go different way. You first decide which one will consider. You have-
This honorable court can mold the relief.
No, that is,
Relief, your lordship.
more
now-
relief if you are not, if you have not prayed for. You have
Yes.
prayed for a distinct, the distinct prayer, which is very difficult to discuss. It's like, first, if you fail, then come to the second. You cannot have that. You cannot have the cake and eat it too. Is not it?
Your lordship. Considering the.
Well, consider obviously.
Yes.
As in today, as of
Yes.
now, you are harping on this advertisement. Your
Yes, at that point of time, I was eligible. That is what I'm just saying, your lordship.
but that's gone. It's a private company
Yes,
now.
but now subsequently also they have in their,
You have gracefully accepted,
yes, your lordship.
accepted your ad hoc appointment.
Your lordship will see.
You go for regulation, asking for regulation.
So I am asking for regularization.
So
of-
forget this, why you are harping on this advertisement?
If this honorable court is, understands that I have a right for regularization under this. On the basis of the facts and circumstances of the case,
But-
that is more than enough.
As of now, you are yet to reach that prayer.
The prayer is,
And this, you will not be allowed to make a submission. The first one is not succeed, then this court should consider the second one. You have to decide before you make a submission. Either you are going for regularization of the present post,
I am,
which those court may allow or may not allow.
Yes.
That is another issue.
I am going for
Or if you-
regularization against.
Or still you are harping on this advertisement.
All this I had to show the background before this honorable court to satisfy the honorable court. I cannot come somewhere in the middle and.
But this court would like to have the,
Your Lordship. So I
Precise-
am just showing these things as the foundation of my case, Your Lordship. At that point of time, I ought to have been considered. But subsequently also, since I have been appointed against that vacancy, and then I was also selected and sent.
because ultimately,
I ought to be regularized. That is my,
no, despite knowing that according to you that all along you are eligible,
yes,
you ought to have been appointed.
yes,
Subsequently, you have given up that the hope and the issue. And the government has appointed you on ad hoc basis with certain conditions. You have gracefully accepted it. You have undergone the training
yes,
as required by the, approved by the government. Now, next issue is you should be considered,
yes,
not because that you have
Yes.
not been selected at that point of time.
yes. I am not.
So you are just, it's
I am just
So-
background stories.
let us forget this then.
Your Lordship, then, if your Lordship is
We'll
satisfied.
record
with
that, record
Yes,
that.
your Lordship, if your,
You are not claiming anything.
I will-
You do have made a submission
yes,
about the advertisement and selection and all
Yes,
that,
yes.
but you have given up.
yes. Let us just,
You gave up that?
let us pace on this government approval.
Yes.
Based
That
on
we can
government
consider.
approval. Yes, your Lordship.
This has been approved or appointed
Approval.
after the writ petition.
Yeah, no. I was, after the interview and all selections were done, again, the petitioner was considered for appointment against the same vacancy. And by this approval, the government, they approved that I be appointed, Your Lordship.
Before
So-
you filed the first writ petition,
Yes,
then the first writ petition was what?
the first writ petition was WPC.
After the appointment?
When I was still continuing, I was asking for regular appointment.
Yes.
Yes, in that earlier case.
Okay,
So
we'll come to that.
Yes.
Let us see the,
now Your Lordship will see there, even A. A is also very important, Your Lordship. A of this approval, Your Lordship. In accordance with the terms and conditions contained in government's notification number EDSA 5/2002 dated 27/10/08. So this I have already shown you where there is no qualifying marks prescribed, Your Lordship. Percentage of marks prescribed.
not only this 45%, you are not having BEd at the
Yes,
time of,
at that time.
at the time of selection.
It is not,
Nobody had.
nobody had, nobody. Nobody had. But as per the school, the notification which is being referred to here. 2008, this is the one I had shown you earlier.
Government is for, not only for all of the candidates,
yes.
all the candidates,
Well,
they,
no.
they were very considerate enough.
Yes,
You have put some qualifications and you have done contrary to that.
yes,
Not only that
So-
45, I mean that mathematics with physics,
yes, yes.
BSc with mathematics, physics and chemistry, BCom, then without having BA, you have appointed,
Yes,
very considerate. Of course, it's a welfare state.
yes. And because of lack of candidates applying for the post, they had to reconsider their stand.
Then next,
So
your
yes,
appointment
two.
order?
A and B is more.
Okay, I've seen that.
Yes, Your Lordship will take that into consideration. Then this is the appointment order, next page, page 30. This is order dated 7 June 2011. Shri Robin Isam, BCom honors, son of Shri Ilamu, date of birth so and so, as per HSLC admit card and permanent address, Woka Down. So and so is hereby appointed on ad hoc basis as GD at Government Middle School, Yonjocho, under the establishment of Deputy Inspector of Schools, Woka, on fixed pay, that is rupees so and so per month. The appointment is made against the existing vacancy, white post creation order number so and so, dated so and so 2009, with effect from the date of joining up to 6 months or till regularization through interview board, whichever is earlier, on the conclusion that he will undergo PA training within 2 years. If he fails to obtain the said professional.
You have joined and then you have undergone this BEd course,
Yes,
huh?
BA course, yes.
Undergo BEd course with your,
Page 32 is the government's order, which allowed me to.
yes,
go to
where is
BEd.
that your
This is dated September 2017.
this is page 33 is what?
33 is the office memorandum with regard to SSA post creation regarding payment of
Service.
salaries of SSA teachers who were appointed under the scheme. Post SSA post creation.
So your salary has been increased to 27,000.
Yeah,
Initially at 8,000
Yes, yes, it was.
and then is your then
Then annexure H, page 34 is
come to
the
that, they come to that last first reposition.
representation, and then the first, page 37, Your Lordship. Page 37, this is 24/4/2019.
So where is your rejection order?
Lordship, page 39, Your Lordship.
It's not legible. Mongera?
Eligible copy will be in my affidavit in opposition.
Cost has to be imposed on you.
Your Lordship, normally the.
It's
registry-
difficult for me.
I know, Your
The
Lordship.
registry should
I-
not
I'm
have
very
allowed
sorry.
you to
Yes,
file such
yes.
a copy.
The registry allowed me to file this. I got
Hopefully-
to-
This is of 2021,
This is
20.
2020, Your Lordship.
Nowadays, you are
Now,
not,
now.
you are
no,
not
no, Your Lordship. Even if there is,
committing such
Yes.
mistake.
even if there is a slight smear also,
Yes.
we have to type the whole thing.
What is the reason of rejection
So,
here?
Your Lordship, if I may read, Your Lordship, number one, downwards, Your Lordship, the said advertisement dated 2011-2009 mentioned one of the main criteria for recruitment to the post of graduate teachers as 45% at degree level, which you did not secure as you scored only 43.75% at your degree level, for which you were not qualified to be selected for the post of graduate teacher. The cancellation of selection of applicants, candidates for appointment to the post of graduate teacher who have appeared the exam as per the advertisement dated 2011-2009 and who have secured less than 45% of marks at the degree course examination can be seen from the meeting minutes for final review of selection and post of graduate and undergraduate teachers held at the office chamber of the German NPSC on 5/3/2010 at para 5. It can be clearly seen that 23 posts of graduate teachers, mathematics could not be fulfilled up as there was no qualified candidates. Copy of the meeting minutes dated 5/3/2010 is enclosed for your ready reference. No other similarly situated degree holders scoring less than 45% at graduate level were declared selected in the final result dated 7/4/2010. Whereas you are very much aware of the facts stated above, and after you failed to qualify for appointment at the interview conducted by the department, you have applied for a vacant post again in 2011 for the post of mathematics teacher at Government Middle School, Yonchocho, under Woka district, and the government approved your application among several applications and conveyed approval to appoint you as a graduate teacher mathematics on ad hoc basis at JMS Yonchocho under Deputy Inspector of Schools, Woka, on a fixed monthly salary of 8,400, for which you were issued in an appointment order that is so and so. That you have already availed the OM number so and so dated 2015. The enhancement of salary from rupees 8,400 to rupees 27,400 for graduate teachers by filing a writ petition in 2017 before the Honorable High Court, Kohima bench, which is self-explanatory. Further, all teachers are required to be trained and therefore giving approval to let you undergo PX training on deputation does not confer any right to you to claim for regularization. That it is pertinent to mention here that in pursuance of advertisement number so and so dated 2011-2009, you have not secured the required 45% marks in your degree course as prescribed in the advertisement by the department, which renders you not qualified to be appointed against the post that was advertised. Hence, your nature of appointment is totally different as you are not appointed in pursuance of advertisement number so and so dated 2011-2009, but appointed in pursuance of government order number so and so dated 35/2011. That it is obvious from your appointment order dated 7/6/2011 that you were never selected in any selection process conducted by the department.
So
Yes.
your submission is that the post where you have been appointed
Yes,
is the same post
yes,
which was advertised.
yes,
It's a permanent or regular post.
yes.
It's not a kind of a temporary or
Yes.
post
Yes,
where you could have been considered for
yes, your lord.
regularization.
Yes, that is my only guess. That is
So
the
that's why
condition of my
as
case.
a backup,
Yes.
you are helping on that advertisement.
Yes, your lord.
Will not consider, will not go by that. I make it point clear. Will consider whether the government can
Yes.
by the rejection has fairly rejected your,
Yes.
fairly consider your case or not, that will look into.
Yes,
Will educate.
and your lordship, I would like to, if your lordship may
Your
also,
backup will not take up your backup.
no, your lordship may take into consideration that because since it is.
No,
a
will
record-
not decide on that because it's a fatal complaint according to this court, prima facie. It's gone.
Your lordship, the
It is a reason because
later,
you have consciously, without challenging the selection process,
yes, your
in
lordship,
all this ground, subsequently you have done it,
your lordship, so.
but
Yes,
you have consciously accepted the ad hoc appointment with all those
your
terms
lordship,
and conditions.
your lordship,
Only consideration has to be whether you could be considered
yes.
fairly
Under the,
in terms of the
in terms of the government approval, later,
government
A and
approval
B.
or not.
A and B. If that can be considered,
Or one thing, you have said it's a temporary post. Obviously, the government will place it whether this is a regularly created post or not.
no, it is a regularly created.
No,
post.
I have heard you.
Yes,
You have
yes.
said so. We'll confirm it to the government.
Yes, yes, so,
Government the one who has created the post, not by you.
yes, yes. Yes, it is created by the government, but it was created, so if his government initial approval letter, where all the terms and conditions are laid down, if I satisfy that, then my case be considered in accordance with it.
But what about this Uma Devi? They say you don't fall under the ambit of exemption for consideration in terms of Uma Devi and ML Kesri.
Your lordship, it is now, I cannot comment on the Uma Devi because that was not my case, but since the government had, it is a fact that I have also earlier appeared
Para
examination,
54
unfortunately, because
Para
of those
50,
problems.
Para 54 of Uma Devi, I think it will not apply in your case.
Yes, your lordship,
Your consideration has to be on its own.
yes, your lordship.
That's all.
Yes, and so in the other case also, since the facts are same, only the district is different, approval letter is
Selection is also no candidate.
same, your lordship. The two cases are fact wise,
This is of Longling,
Longling, yes, yes, but the approval,
Yours is Waka.
yes. This one is, the first one is Wokar,
Approval is also
same, your lordship.
same day.
Same one, and the same date only. If your lordship may, I'll take your lordship to the petition. I'll take your lordship straight to the approval, your lordship.
We'll just,
Yes, this is also 30th May. This is 30th May, both of them. Page 29, page 29. And in his case, in December 2012, he was sent for the requisite training under the NCT, your lordship, which is at page 32. Page 32, along with many others. His name is at serial number 43.
any case law in your support of your
Because since your
submission.
lordship, we have decided not to enter into the that aspect of the matter, I
No,
was,
this was the privacy view of the court.
yes,
We have not decided as yet. We are yet to hear the government council.
yes.
So it is you to take a call. If you insist on,
If your
Those-
lordship may fix another date, because now that the course has,
no, your prayer also consider petition of a regular appointment retrospectively from the date of initial with all consequent benefits being shown and hearing the parties make the. Your prayer is also on that only.
yes, on that only, my.
He is not challenging that he should be appointed
Yes,
Your lordship,
with effect from the date of the that from the day when the other candidates were appointed pursuant to the advertisement was appointed.
Yeah.
He's talking about with
Initial
initial appointment of ad hoc.
ad hoc service, your lordship, that is the thing that your lordship, all his petition is routed through the advertisement. And he's bringing, dragging along all this advertisement and
He said,
at last he is praying for regularization
Ah.
on, basing on that. Your lordship, but how was he appointed on ad hoc basis, your lordship? The government is gracious enough, your lordship.
that I hear you, but
And
that's why I'm saying you first decide that.
your lordship, I have, since my prayer is also like your lordship is saying, from the initial appointment, I should be considered for
So
regularization.
he as a
And-
backup,
Yes,
as a backup to his case,
yes,
he has, as you said rightly,
yes,
started from this thing and how
Yes.
this is, could not
Yes.
consider why he has not been appointed, he ought to have been appointed. He started that.
yes.
Now ultimately, it has boiled down to regularization.
but that cannot.
So he has clearly admitted that he has given up about those advertisement and all. It was
Yes.
just just to narrate the entire
Yes,
episode
yes.
as a backup. But the basis of claim is not the advertisement,
Yes,
is it?
yes, your lordship.
But can you,
Consequently,
the string for praying for regularization has a string to the advertisement, your
So
lordship.
we'll not
So, your lordship, but you're not,
we'll consider it different, separately.
but however, your lord, as far as the regularization.
Whether he can be or he cannot be,
yes,
after hearing you, and we'll take a call.
yes, your lordship.
Ah.
My, since the report is very clear, the government approval letter is also clear.
Because
Based on that also, the matter can be decided.
Hmm.
Government approval letter is very clear. They have. laid out the-
And one more mistake is that your rejection has not been under challenge. You have
No,
not prayed
no,
for
we have
passing.
not. I have not. I am only.
This is actually a string from advertisement.
I only want to show the narrate the entire facts of the case, how I was appointed. That my case is a unique case. I wanted to project before this honorable court that my case is a unique case. That is the only fact I wanted to project. And based on that,
Once you,
Because of that-
once you,
because
once
of that-
the court has directed
yes,
to consider your case, that has been rejected.
yes,
And thereafter you are approaching this court,
yes.
challenging that without challenging the rejection.
No.
order. How this is
Because
possible?
now your lordship, what
How
happened-
do, how do we,
Yes.
how do we interfere?
What happened was subsequently I came across the NCD notifications and the
That is gone,
government
that
notifications.
is gone, why not?
So now, based on that, I submitted a representation. Based on that. Not they have rejected me. Now, subsequent to that, what happened was, the petitioners came across the position of law which was in place at the relevant point of time. They didn't know about that position in the earlier writ petitions, your lordship. In the earlier writ petition, they had no knowledge about the NCD notification. The government notification which was in place.
Again, you are,
So because of that, we have submitted one representation, but your lordship, at the end of the day,
you are back to square again,
Yes.
if you say so.
no, why I am saying all this is to project the.
The
unique
difficulty is
case on your-
you have not challenged the rejection order. Wrongly or rightly.
We have not, we are only saying that my case is unique.
No.
It has been appointed in this.
Therefore, this court has directed to consider your case for registration,
Yes, your lordship.
but then they have rejected.
Yes, your lordship.
You are not challenging that.
No, because we are still continuing in service, your lordship.
Doesn't make a
We are,
difference.
so regularization may be considered at least in terms of the government approval. Government approval is clear. So since it is clearly there on record.
No,
On the basis of that alone.
whatever may be,
Yes.
they had considered
Yes,
your case and rejected.
yes,
Whatever may be the ground, good ground or bad ground.
your lordship.
If you are not challenging that, how can this court can interfere the rejection? They will pass an order saying that we have already rejected. He's happy not to
No,
contest
your
this.
lordship, in the earlier case, in the earlier petition, a direction was given to consider our case.
Yes,
Now,
that has been rejected.
in the present case,
Present case, you have not challenged this.
if your lordship may direct that this case may be considered on the basis of the government approval and subsequent appointment, that will suffice, because the government approval is very clear.
That should be, have some basis. That will be innocuous. They will again reject it.
Your lordship,
They will again reject it.
Your lordship,
That we have considered this is because of this will consider.
your
reject
lordship,
it.
they may also do that, but whether it is consistent with the government approval or not, that is the position. In that case, if they are saying that we are not going to
No,
consider.
we want, this court would not
Yes.
like to pass any innocuous order.
Yes, yes,
Where neither here nor there. Where it multiplies the cases,
your lordship, yes.
litigations.
So if your lordship. may-
Therefore, unless the petitioners comes with a handle, it's very difficult.
Oh, your-
You could have challenged this,
Yeah, yes,
challenge and asking for a regulation based on all those things.
your lordship,
that could have been a different
your
thing.
lordship,
Uh,
Was
if your lordship may confine to paragraph A and B of the government approval, it will be to consider my case on the basis of
No,
that.
whatever,
Yes,
with the reason others,
yes, yes.
wrongly or rightly, your case has been considered and rejected. And you have not challenged that.
Your lordship, now my case would be, since it was not based on this government approval. The government approval, now if a direction may be given on the basis of the government
What is that
approval.
in that case?
Yes.
Will it simply pass an order that in view of this government approval condition 1 and 2,
Yes, yes,
the case of the petitioner may be considered.
No, your lordship, yes, your lordship.
You consider and reject it, that's all, finish.
We have already rejected it, your lordship, by our presentation. It's amply clear, it's crystal clear, your lordship, self-explanatory, your lordship. And now your petitioner, like after getting rejection of his representation, he has checked among all this advertisement and all our affidavit is based on that, your lordship. And now, if you particularly take out that realization, your lordship, it will be a different whole thing.
Your-
And this point you cannot give your
the
lordship.
position of law estates. If I had not brought in all these records, they would have said that I am suppressing material fact.
Your
On the
lordship.
basis of suppression of material facts, this petition would have been rejected, your lordship.
No, your
They will take the stand.
advertisement will never occur, your lordship, because he has not challenged it.
It is no use harping on all those areas, your lordship. But. if-
It's okay, before
Yes,
I hear her, do you have any case laws in support of?
your lordship, if on the basis of the government approval letter of for my appointment, those conditions, since these are the conditions not made by me. It is the conditions laid down by the government. So if on the basis of that, a direction be given that my case be considered in terms of the terms and conditions laid down under the government approval, then I would be more than satisfied.
Your lord, how much consideration you will give?
It's okay, it's his submission.
Yes. That is my humble submission.
You could have, in that case, you could have finished the matter within 10 minutes. Anyway,
Yes.
no other case, no case laws.
No other. I was planning to go into all the.
Different
aspects,
road.
Because even as it is, the 45% percentage, it is null and void. Since it is against statutory provisions, that was my case. And this honorable court has also in catina of decisions given those decisions. That is why I wanted to satisfy your lordships, but now your lordship has also understood and narrowed it down to this aspect. My submission will rest on this government approval letter.
That is based on your prayer and your
Yes.
the
My-
nature of your
my prayer-
submission.
Yes, my prayer is also more or less covers this only.
But difficulty is there. You have not challenged the rejection order.
Your Lordship, that rejection order was not based on this, Your Lordship. It was based on the earlier exam. On the earlier examination which was conducted. They are saying that you did not have the 45% mark. Now you are not come, you cannot come under that category.
That is one
That is
part.
what they are
That is
saying.
one part.
Yes,
Second, there are some other reasons also that it is adopt
yes, that it is.
under any under
Yes, that is-
SSA
Yes,
could not have been,
yes,
including your that case doesn't fall within the ambit of exception at para 54 or Umadevi.
Your Lordship, that is what they are saying, yes. But since my case is covered by this approval.
No, they say in terms of the,
Yeah.
as per the terms and condition of your appointment.
Yes.
They said so. They have said,
Yes, we have actually explained to him as to why we could not consider his recommendation.
okay,
So now, Your Lordship, if Your Lordship will allow me to take Your Lordship to that case, it is okay. Your Lordship will also grasp the nature, if the case which I was going to refer
hmm,
for a wider understanding of the entire issue. But my prayer will all be on the basis of this. Your Lordship.
don't go by your prayer only. So why we should go
My
there?
submission will be based on my, for consideration of their case on the basis of this government, which now, since 2011, it is now more than 12 years. So we have already served, and then we have also complied with the terms and conditions of the notification. And they have also appointed us on the basis of the 2008 notification, that is, because with regard to the non-requirement of the percentage of marks. Non-requirement of the percentage of marks. Otherwise, we would not have been appointed. But under 2008, we are qualified, Your Lordship. And they have clearly mentioned in the paragraph A and B that it is on the basis of that 2008 notification that we are being appointed. So now,
So
yes.
we resume at 2.
Yes.
And you 1 hour is there, you think about it,
Yes, Your Lordship.
think about it. Whether you stand by what you have made a submission or not.
Your Lordship.
Difficulty is there. Because you have not challenged the rejection order. We'll continue at 2.
Yes, Your Lordship.
We'll hear after some time.
Yes.
We'll hear you for some time. Few minutes and we'll
Your Lordship.
hear her. Yes, a book.
Yes, your lordship. I am very sorry, your lordship, but since I have also to go by my pleadings, your lordship, because my case rests on the pleadings and the reports. So I would like to take your lordship to my one or two paragraphs to my pleadings, my important ones. And then I will submit one judgment and your lordship can apply your wisdom to that.
Hmm?
Your lordship may apply your wisdom to my submission. But I would like to take your lordship to one or two of my the paragraphs, the important paragraphs, your lordship. And then since the facts, how the petitioner had proceeded from the very beginning. It is now already there. I have already submitted on that.
No, I've heard you
Yes.
about the facts and all.
Yes.
If you have any law, you just show me. If you're relying on any case law, that's all.
Your lordship may allow me to take your lordship to the one particular paragraph, your lordship. Two paragraphs only.
In the writ petition,
Yes, yes.
for what?
Your lordship, paragraph 9.
Yes,
Paragraph 9, that in 2017, the department had issued information that an eligibility test would be conducted for regularization of ad hoc employees of the department who have completed 3 years or more of continuous service and called for submission of all necessary documents. The petitioner being eligible submitted the necessary documents to appear at the test. Subsequently, department issued a press release, white number so and so, informing the ad hoc that written tests would be conducted on 23rd May 2017, for which the employees were directed to collect the admit card from 16th to 19th of May 2017. However, in the annexure P to the press release, it was informed that 11 ad hoc employees, including the petitioner, would be deleted from the list of first submission. Thus, the petitioner was not allowed to appear the eligibility days, whereas those who appeared the days were subsequently regularized in service. So this is one pertinent fact. In 2017, this happened.
where are those documents?
Your lordship, the state respondent has not disputed this fact, okay? I have not. Your lordship, with the affidavit in opposition filed by the state respondent at page 4, paragraph 8. They have given an excuse there, but they are not stating that we were, my statement is wrong. If I'm reading, paragraph 8. That in regard to the statements made in paragraph 9 of the writ petition, the deponent states that the eligibility suitability test conducted by the department in the year 2017 was only for the ad hoc employees who were holding posts under the state government, including those graduate teachers and undergraduate teachers who underwent the selection process and qualified the interview conducted by the department of 8/1/2010, but did not include the petitioner and other similarly circumstanced persons who did not qualify for selection process but were subsequently appointed as graduate teachers matched on ad hoc basis under the RMSA SSA scheme.
What is this 8/1/2010
Your Lordship,
interview?
the state respondents alone knows it, but the notification, the following, the notification contained no such thing. Only those who have qualified 3 years of service.
The notification you have not annexed, where the notification? Unless you annex that notification showing that it includes your candidature. I mean, you are also eligible for appear as per the notification. how to respond to that? They are saying that
Yes.
is notification only for those persons who appeared in the interview or qualified interview of 2010.
This wasn't. This was in the form of a press release subsequently in 2017 and 2017.
They are saying that it is for those candidates who has
that-
qualified the interview in 2010.
At that point, your lordship, they are saying that, but those who have cleared the interview, the question of selection dates does not arise. They were appointed regularly. They were, if they had qualified the interview, the question of having another date does not arise in their case. These things are going on internally in the department.
And you have not challenged that also.
We are not challenging any, we are just submitting that these are the facts that we have undergone now.
It's
Your
okay.
Lordship.
Facts.
Now, your lordship, my one paragraph subsequent to that, your lordship.
To
Yes.
come to a conclusion, it has to be substantiated by the documents.
Now,
Neither you nor the department is relying annexing any documents.
your
How
lordship,
do we
one-
conclude?
One problem, one issue with regard to non-challenging of the interview that was conducted in
We'll
2009.
just say you have stated so, but
Yes.
cannot be
Yes.
concluded. In view of
No.
the lack of the supporting documents.
No, they are not saying supporting documents, but they are saying that we were not eligible under that. That is what they are saying. But whereas all other teachers were eligible, only a few of us were not made eligible under that.
That you have not
Yes.
challenged also.
We did not challenge it.
You're just narrating the
Yes,
facts.
yes, we are.
What had happened.
Now, your lordship, one issue with regard to non-challenging of the interview in 2009. The vacant, we are not agreed by the selection of the others. But the vacancy which was still there. Against that, we were subsequently again appointed. Where it was shown that there is no candidate. So now, in this case, it can be assumed that we were
Appointed
appointed
on those posts,
on the basis of the earlier.
but they have rebutted it.
Yes,
They have
we were
refuted
selected
it.
on the earlier, on the basis of the earlier.
They said it's not
Yes.
that post was something else. This is the post where you have been appointed under SSA
They are
on ad
saying
hoc
that.
basis.
Now. Paragraph 18, your lordship.
Yes. Yes.
Paragraph 18, page 16, your lordship. That the petitioner respectfully states and submits that although he was granted a top appointment not on the basis of the selection examination held in 2009, yet from the report it can be asserted that he was selected at the same examination and only because the state respondents applied the criterion of 45% mark in the degree examination, which he did not possess. His selection was cancelled. It is also clear from the report that at the time the selection examination was conducted, the standing government policy as well as the NCD notification did not require any percentage of marks in the degree course for a person to be eligible for appointment as a teacher. But the Directorate of School Education arbitrarily inserted the condition that the candidate must possess 45% marks in the degree course. The criteria of 45% specified and applied by the Directorate of School Education was therefore called ab initio, being contrary to the existing government policy. It is also a fact that although the petitioner did not possess the requisite 45% marks in the degree course, he was allowed to appear at a selection examination. And as it is apparent from the report, he was placed at serial number 1 of the successful candidates at the written examination and was called to appear at the oral examination. And obviously, he was selected for appointment, but only because he did not possess the 45% mark in the degree course, his selection was cancelled. However, the fact that he was subsequently appointed on ad hoc basis to one of the appointees posts shows that the department deemed him eligible for appointment. And certainly, consideration of his performance in the selection examination must have played a role in his appointment on ad hoc basis. Later again, the department, as required by the relevant rules, selected the petitioner to undergo the PN course, which he successfully completed. The petitioner having been deemed eligible for appointment and accordingly appointed on ad hoc basis. And thereafter, the department having selected him to undergo the PA course. The respondents ought to have permitted him to appear the eligibility test conducted by the department for serving ad hoc leaders who have completed 3 years or more service. By then, in the month of May 2017, but the petitioner was denied this opportunity also. For reasons known only to the respondents and other consequences, while the petitioner continued rendering service on ad hoc basis, those teachers who were permitted to appear the eligibility tests have been regularized in service.
Did you appear for Baiba Bose?
Yes,
So admit, there's no dispute that you were selected, qualified in written examination.
yes,
It doesn't mean that you were selected after Baiba Bose. You could be disqualified, even not for 45%.
Your Worship,
Even if,
yes,
even
but
if,
my-
even if law says, even if you are selected, still then you don't have an indefeasible right for appointment. In
yes,
such a circumstances, how you can be directed, how can this court direct the authorities to regularize the service just because you have not been unduly, disqualified? Except for qualified in the written examination, there's nothing to show that you are eligible after, qualified after Baiba Bose.
Your Lordship,
Ground may be 45%,
yes.
but there's a cloud in between. 45% and after you were qualified in written examination.
From my
Am I right?
humble submission.
You are not able to show that after Viva,
But influence can be shown from the result itself, Your Lordship. From the final result.
no, final result is no candidate.
No candidate. So now what is the reason for the no candidate?
No, we cannot have
Yes.
assumption and presumption.
No, your stand is that no
It
candidate.
has to be supported by documents or the facts
Yes, your Lordship,
clearly.
their stand is that because of my.
You want this court to assume that you qualified after the Baiba. There is nothing to show that you are qualified after the Baiba. Final selection is after the Baiba. You are able to show that you are qualified up to written. We admit that. And we are agreed and satisfied that you qualified in written examination. Thereafter, there is a cloud. You are not able to show. What happened?
Now the position.
Why are you not able to show that after the Baiba, since you have appeared for the Baiba, that you are qualified? Had it not been 45%? I agree that you are number one in written qualification when after the written examination. Even if you are number one in the written, it is not always necessary that you will be selected
Yes,
after the Baiba.
Subsequent to the filing of the petition, the petitioners applied for the oral result, Your Lordship.
Interview.
In the oral interview and the final total marks, the results were also there. The marks are also there. But since the matter had already proceeded, we wouldn't file any affidavit, but to satisfy Your Lordship, this is the RDI. report which was given.
You should have filed that along with that,
Yes, Your Lordship.
giving the chance to other side. I may looked into it, but it's of no use. Cannot take cognizance.
Your Lordship, so since they
And-
are
and-
already
and-
saying-
and you are
they
rely-
already
you are-
saying that,
You have relied on para 9 of your writ petition.
yes.
They have categorically said so.
Your
On what
Lordship,
basis, and you have not replied also.
Your Lordship, my only submission is how things have come
How?
to this extent. why we are,
Why you have not filed a reply and additional affidavit? When did you obtain that mark sheet?
Because only recently I received the copy, it is still present of October 2021, but only recently I received a copy
When?
from the petitioner.
When? It's in between you and the petitioner.
About,
Which
2 months.
date you have received that?
yes,
From the department?
about 2 months.
From the department. When did you receive that copy from the department?
copy is 13th of October 2021. But this is the.
2 years before.
But their stand is that they are not saying that we were not eligible, we did not clear, but their sole stand is that because
No, you have to,
we did not have the,
since you are before this court, you have to satisfy this court, not to the respondents.
yes, but their only stand is that they did not.
If you want to satisfy the respondent, go fight there in the department, why you are before this court.
Yes, Your Lordship, this is why now the only issue is we were found to be, not that we did not pass the examination, but we were found to be not possessing the 45%.
If we had to take the if we had to take the support of the background of your case, you will have to establish that all along you are eligible. Had it not been 45%, that is your projection of your case.
Yes,
But
that is my position.
after 30, written examination, there's a gap. You have not talked about your Viva result and all those things, how much you have qualified.
Yes. Because at that point of time, when the petition was filed,
One thing you have done a mistake is you could have filed a,
yes, yes.
by filing an additional affidavit and then file a reply to the, you see,
Your Lordship, in the
it's not in all the cases, that's why you have to be very careful.
may I make a small,
It's not all the cases where reply affidavit is required, but it depends on the case to case. The slight mistake of not filing,
Yes.
casual approach of not filing,
may I
it will
make
have a
a submission?
detrimental effect.
If Your Lordship may allow me, I'll make a humble prayer. If Your Lordship may allow me to file an additional affidavit with regard to this.
At this, it's very difficult.
Your Lordship, it is-
I've been hearing you
it is-
since
yes,
morning.
It is in the hearing stage, Your Lordship, but in the interest of justice, if Your Lordship may allow me to file an additional affidavit.
What does it say?
Putting on record,
It shows that you are number one.
we are, the marks, Your Lordship will say that, so it clearly, yes. Not number one.
Just make a submission, we'll see.
Yes, it says. If Your Lordship may. have a
You
look.
just make a submission.
The written.
Because since it's not a part of the record,
The written examination. Is.
final result.
This is
After the Viva,
After the Viva, the petitioner. At the Viva,
how much he has obtained?
he obtained 18 marks.
Out of,
The highest mark is 19.
out of,
Out of. No full marks is given, but he obtained 18 marks. The highest mark among them is 19. Two of them obtained 19 marks, two of them. And the
how
other,
many candidates were there?
there were 9 only.
Nobody, no one has been appointed.
All of them were appointed, only the petitioner was left. All the others were appointed, because there were 9 vacancies in the written, 9 of them were there.
Mathematics,
Yes. In the written, 9 of them appeared the exam.
then when they say,
Then-
when they say it's, there's no candidate. Why they have said no candidates?
these marks were not published, Your Honor. We had to apply for it. We had to apply for it.
Where it said no candidate,
Your Honor, page. Annexure,
page 24,
yes,
annexure B2.
yes,
Huh?
yes, only in respect of this, only one, no candidate. In the rest, all the other candidates are there.
For other school.
Yes, for the other schools. For the other,
Just show me.
yes.
Give one copy to her also.
He's at serial number 6, Your Honor. His name is at serial number 6.
This is total 9 candidates,
Yes,
irrespective of the subject.
this is with regard to mathematics only.
Huh?
Mathematics in the various schools.
Those schools.
Yes.
Your school
In the
has,
district. Yonjocho.
so one post, one candidate. How
Yes.
many candidates for your school?
Your Lordship, in the written, they were the ones who were selected. In the written.
No, no.
It is only the state respondents who know how many were selected in the written days. But these were the ones who were selected in the written days and made to appear there or.
See, in
Watching.
written test, you are the
Yes.
second last, 20 marks.
Your Lordship, overall, total, Your Lordship will see. The one lowest is 34, 37. And
And
then,
then, that's what I'm saying.
yes,
Your written is your the lowest, second lowest.
but I was selected in the written. Your Lordship.
Lordship, there is a slight clarification, Your Lordship. Under Woka district, there is a different places, Your Lordship. So in the place where the petitioner is seeking appointment, Your Lordship, there is only one post, Your Lordship. One post of maths, one post of science, and one post of English. If you can say, go to the advertisement, it's very clear, Your Lordship.
Yes.
So not all these 9 posts is against the same place, Your Lordship. It's in different place, one district, but different place, Your Lordship. And in different schools, one post was available, Your Lordship.
No, written, he was the second last.
Yes.
Last is obtained 18.5. He obtained 20 marks only.
Yes.
You are the second last. You could not have been selected also.
No, Your Lordship, in the written days, I was selected.
It was a list.
It was a list, Your Lordship, but I was selected for, they earmarked 9 persons for 9 posts, Your Lordship. In
This
the
is
written
also
days.
little strange also, no? You are recruiting a,
So they were the best among all the candidates.
you are making recruitment,
Yes,
one post, one candidate.
Well, in fact, there is no person actually for the post, required post, you say.
Yes.
Even the petition was not qualified, Your Lordship.
so,
That is the position, Your Lordship, not only in this place. if you see the advertisement on the result, you see in many places the restaurant not admitted because of lack of qualification, Your Lordship. So it is not only the case of the petitioner, Your Lordship.
So during in the written exam, based on their marks, 9 of them were earmarked for the 9 posts. And the oral was conducted. The oral was conducted. So altogether, there are 2 other persons who received lesser marks than me. They were appointed because they were.
It is not happily conducted selection process.
So that was the position, Your Lord. So their case is not that.
And then it is for
Yes.
teaching. If there's no, these are for teaching professions, the government could have a policy for outsourcing also.
No, Your Lordship, now if he is bringing this new record, we can actually ascertain, Your Lordship. Now, out of all this 9, how many person have gotten as to how they have got the appointment? Here in our case, Your Lord, the petitioner has not scored, Your Lordship. He scored only 43 point something percentage. He was not eligible, Your Lordship. And therefore, he was not qualified. As for the others, if the court permits, I will bring an instruction as to how they are appointed. And we don't know whether they have been appointed also. We have to see.
He is praying that he may be allowed to file this broken record by filing additional affidavit.
That's up to the court, Your Lordship.
No, at this stage,
Yeah, even if material.
this court is not willing, but then is a little reluctant, but then if you don't have any objection, we may ask him to.
No, Your Lordship, the thing is that even if you file this thing, it's immaterial as of now, because Your Lordship, it's not challenged advertisement, Your Lordship. First of all,
That is another issue.
it's not a challenged advertisement. Now it has been unsuccessful, Your Lordship.
No, that we consider.
Yes, Your Lordship, and now we can.
I'm thinking
Selection.
tomorrow, it may not have any bearing for you. But if he thinks that it has some bearing on his, let him make a.
No,
and
Lordship,
if
I will
you
make
have a-
that also, Your Lordship. To substantiate that I have a ruling, Your Lordship.
Which ruling?
Regarding the advertisement and other also, Your Lordship, I can satisfy this court, but if the court deals with, I will let him file and I will also file it. I will also have to file counting that one, Your
Yes.
Lordship, because we have to make everything clear before this court, Your
Yes.
Lordship. And otherwise, Your Lordship, it's immaterial, because Your Lordship was unsuccessful all along.
Are you serious? It will have some, it will help to you?
Your
No.
Lordship, initially I wasn't, but Your Lordship was raising the issue about whether he cleared the interview or not. So
He qualified the oral.
whether he qualified the interview or not in the exam. Your Lordship wanted to know that. This is why I have brought it before Your Lordship.
Okay,
So if Your Lordship allow, will that
it's okay,
he
it's
has
okay.
been cleared, he has, that shows that he has actually been selected.
This is admitted position.
Yes.
These are the score.
Your Lordship, this petition, I mean, this document, if I'm not mistaken, has been obtained through RTI.
Yes.
So Your Lordship, I also have to
Okay.
seek instruction.
Huh?
I have to seek, because Your Lordship, here now the petition is,
Sent by the additional director and PIO.
this is an RTI, Your Lordship.
In that case, we'll hear you, and if you have some any reservation on it.
Yeah, Your Lordship, if we have to, if this court have to approve this petition, this document, then Your Lordship, we have every reason to seek instruction on this and give a proper reply, Your Lordship. Because this document is new to me, all this, now is putting that all these like persons are selected, he's on military, when he's selected, all these questions are coming, very irrelevant. But at least, Your Lordship, if he's placing this and this court, admit this document, then Your Lordship, I have the right. But it is it's irrelevant, Your Lordship.
I'll file it tomorrow, Your Lordship. I'll give her the copies. And then if she wants some further instruction based on that, then a week's time may be given, Your Lordship. And then the matter will be taken up as part of. I'll file it tomorrow. I'll file the additional affidavit tomorrow. And then your lordship may also pass order that I'll give her the copy tomorrow itself. Then she can take the instructions with regard to the genuineness of this.
Any objection?
No, your lordship, I don't have any objection. For the clarity before this honorable court, for judicious passing of the order, your lordship, I don't have any problem.
So you will give you 1 week term. We'll fix it after or somewhere in next week. For final, we'll say the remains inconclusive. We'll not say part hard, but we'll dispose of on next date.
Your lordship.
You file this by tomorrow.
I'll file it by
Copy maybe.
By Monday, whatever you want to
Yes.
reply.
Yes, your lordship, please, your lordship.
Or otherwise, tomorrow they may say, these are the documents, official documents, but
Yes.
then we have not been given. Because it's at the, hearing stage is very difficult, but then
I know.
let us be little,
Yes.
frankly, little
I
liberal.
am.
Because
I am-
there's no
yes.
urgency as such also.
No problem.
Heard Mr. Tongpo Pungan, learned counsel for the petitioner. And also heard MS Libika, learned state counsel for the respondents, all respondents, no? Hearing of the matters remain inconclusive. List the matter for further hearing on, you fix that after next week, huh?
Thursday,
Thursday.
next
which day?
Thursday.
Next Thursday is which day? Somewhere, next Thursday is 14, no? I don't think so. 14. September. Ah, 14. Ah. Next para, the learned counsel for the parties may file appropriate application. Well, may file appropriate affidavits if so advised. You file it tomorrow
I'll
with the
file it.
understanding that you'll give
Yes.
it to her, and by Monday, whatever she
Reflected
wants to.
instruction.
Your Lord.
You may not, if you don't want to file, you just take the instruction
Your lordship,
in
I
writing.
can obtain instruction.
And you just, one more for clarity,
Yes, your lordship.
so far as para 9, you take
Mhm.
instruction also. You have said that in reply to his para 9,
Yes, we have given a
you
reply.
said that these are the candidates who have qualified in the interview held in 2010.
Yes, sir.
Specific date is given.
Mhm.
In your affidavit, para 8 of your affidavit.
They're para 9, right?
Yeah, para 9, you have
Para 8.
answered in para 8. What they are saying is, there is a
Sorry,
notification.
your lordship, your lordship. I'll
And
do
have
that.
have a whatever oral instruction.
Yes, your lordship. Your lordship.
So 14.
May I please your lordship? 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 Am I audible?
Yes.
My lord, at first, I want to put two facts before your lordships for kind consideration. My lord, in this matter, their subsequent development has taken place in overall with respect to the Unlawful Activities Prevention Act. Number one. Number two, there are certain additional documents which I would like to place before your lordship for an efficacious disposal of this matter. Because earlier on 2 occasions, Honorable Justice Borua was hearing this matter, and later on the matter could not be disposed of. And subsequently, the learned PP who was representing the NIA, Mr. N. Mishra, he did not turn up. He left the organization, as I have been told. Now, your lordship, there are certain developments have taken place with respect to this matter and overall the Unlawful Activities Prevention Act. Number one. Number two, your lordship, this matter pertains to the money giving to a proscribed terrorist organization called NSCNK. Am I audible, my lord?
Yes, yes.
Yeah. So, my lord, what happened? The bails were been granted by this special court NIA, subsequently rejected by the division bench in the principal seat when the NIA appealed against those orders. And those orders were been challenged before the Supreme Court. Now, recently, the Supreme Court has passed the judgment setting aside the High Court's order, relying upon the ratio laid down in this one, Tessil's case, where the extortion, where a victim of extortion cannot be equated with the at par with the terror financing, because we are all victim of terrorism in this matter altogether. So, my lord, there are certain developments have taken place. In light of this, I would like to file an application, provided your lordship will take a call on this matter.
No, obviously, if that is the developments, you cannot be prevented from filing the application.
No.
In fact, there was no bar as such. You need not, I mean, obtain any permission from this court. You could have filed it immediately.
My lord, no, my lord, as an officer of the court, I must put a fact. Since the hearing,
in that case, we'll adjourn the matter. You'll file the appropriate application as and when, if so advised.
my lord, no, my lord, there is one more thing. One more
Yes.
thing. I would like to apprise this honorable court, and my lord may.
You are for petitioner.
I am for the petitioner, my lord.
He is the petitioner.
I am the petitioner.
You are for NIA.
Yes.
IA is for what?
IA is for this honorable court granted for stay in the trial court proceeding.
Huh?
Stay of the trial court proceeding, my lordship.
Okay.
Taking.
My lord, that I was.
You want that the trial should proceed.
Please, my lord.
Therefore, you have filed this IA.
Please, my lord.
Because in the
Since
petition, there is stay
Please,
the proceedings. So do you have any idea what have you heard what the learned counsel for the petition said?
Whatever the bail is different, but whatever the people want to file before the trial court for discharge application, whatever. But it is whatever the petition is filed. The prayer is the challenging of the notification, which notification NSNK has declared as a banned terrorist organization.
No, whatever.
My lordship.
What the learned counsel to the petitioner is submitted is that there's a development
My lordship,
in the connected matters.
Supreme Court granted bail. Honorable High Court in trial court is rejected by NIA challenge before.
And at the same time, he said there's a change or development in the law itself.
My lordship, it is not.
So for that, he would like to file an application. We cannot object it to it. I mean, we cannot. We'll see. Let them file it. We'll see. You will have a chance to reply to that.
My lordship, please, my lord. But
my lord,
kindly vacate the stay, your my lordship. My witness are one is going to be dead. My witnesses in this case already 3 witnesses are dead.
No, it's okay. If you accept it, if you accept, say, if you accept the submission of learned counsel by petitioner, that Supreme Court has said, I mean, had held that you cannot equate with the person who has been the subject to the, I mean, what do we say?
At same par, my lord.
Equate with the person who has given the money on extortion with the accused, who is.
That is for bail, my lordship. I have.
No, he said That is the Supreme Court. We'll see. We'll see next day.
Supreme Court is saying that it has to be for bail purpose, Supreme Court has to be analyzed. Prima facie, how to prima facie has to be considered for granting bail or rejecting bail, that to be considered. My lord.
Okay, we'll consider you make your submission that day, let them file the.
May I please, your lord?
When?
Fifth of October, my lord.
5th of October.
My lord, if your lordship permits me, may I make a short submission?
Yes.
My lord, with utmost respect to my colleagues in the bar, when the earlier matter was listed on 8th of August, my learned colleague from NIA, he made a submission before the court that because of the stay order, the trial proceeding in this case has been held up. My lord, it is thanks that everything is now recorded in this digitized area. My lord, it is a purely a false statement has been given because the High Court, when granted the stay, did not held the entire matter, only restricted the operation of stay with respect to the petitioner before your lordship. So making a this omnibus statement, it does not fit his status. Number one. Number two, your lordship, recently this Honorable High Court at the principal bench has passed a judgment in the criminal appeal. It was the first NIA case where the Honorable High Court, may I read the operating portion, my lord, if your lordship permits. May I read it, my lord?
No, there may be a difficulty, except except the interim order is for the petitioner accused number 4. So there may be a difficulty in proceeding with the matter.
My lord,
So let us not, you may not face the difficulty, the court or the prosecution may be pressing it. So will not make a unnecessary controversy of it. So if you are, what is your prayer? If you want to file some application, we'll grant you some time.
Absolutely, my lord.
And your learned friend has agreed to that the matter be fixed.
My lord, my lord, my lord.
Of course,
I will give them a
he also has a absolute and full right to make a submission unless it is a false submission or the unrealistic. All right.
My lord, my lord.
Okay.
My lord,
You use the mic.
Who are the vital witness in my case already since from 5 years?
Use the mic. So that your learned friend can hear.
My lordship,
Yeah.
already 5 witnesses are died, my lordship. Who are the vital of this case? Suppose if he is dead, then where can prosecution has to grab the witness? Then my case will be 0, my lordship. Therefore, my prayer is to be whatever the evidence to be analyzed by the trial court, please pray.
on a lighter note, I must say, when one similar matter was being heard by the division bench presided by Honorable Justice Sarto, where my learned friend was a PP, the Honorable Court said that instead of making this person an accused, you should have made them a star witness. And later on, they did that in one Railung matter. The victims, they have been portrayed as an accused. I have been aware because I have been dealing with NI matters. The IO of this case, Mr. Jasbir Singh, unfortunately, he also passed away a couple of months back.
So your friend is Mr.
Satyanarayan, my lordship.
Satyanarayan.
Satyanarayan.
Mr. Satyanarayan, your learned friend is suggesting you better course of action. You think over it seriously. I'm also on a lighter note.
Please, my lordship.
You think about it seriously. Your friend has suggested you a better course of action
Please, my lordship.
in such a situation.
Please, my
But it's on lighter note.
Yes. My lord, can I fix
Anyway.
it, my lord?
Your friend is said 5th of October.
My lord, 5th of October, it will be difficult. Why? Because the learned
And I request that next time this court, if happens to be taking up this matter, will not grant you to permission to appear through BC, but would like to request you to present in person in Kohima.
My lord, I would have loved to come down because I have met with an accident. My right leg, I suffered serious injuries. So I'm unable to travel.
No, you are in Gauhati.
My lord, I'm in Gauhati. I'm appearing from my house.
You have a flight? From
My lord.
Gauhati to Dimapur.
But this time I will be coming. Next time I will be coming, my lord. I will be coming. Can it be in the month October, my lord? Any day after 5th of October, because 5th of October, the division bench has set up a matter where the Honorable AG of Nagaland will be appearing in a service matter. So, my lord, it might go for 2-3 days. So, can it be any day after 10th of October? Any day, preferably Thursday, Friday.
My lords,
Huh?
please, my lords, whatever is suggested date after 10th of October, I will do.
He's ready. You,
My lord.
Whatever date after 10th, you are physically, personally present.
I will be there. I will be there, my lord.
heard Mr.
S. Borgohai.
S. Gauhati, learned counsel for the petitioner. Also heard Mr. Satyanarayan,
Respondent number 1 and 2, my lords.
learned counsel for the respondent number. Respondent number 1.
1 and 2, my lords.
1 and 2.
1 and 2. 2 is no more, my lords. Now is that. 1 is the NIA.
You are 4?
Respondent number 3, my lord.
3.
Union of India.
3. The Mr. S. Borgo had learned counsel for the petitioner. Submits that there is a there's certain developments related to the present matter for which he pressed for some time to file appropriate application placing such developments. Mr. Learned counsel for the respondents fairly submits that they don't have any objection. If there is a development, Mr. in view of the above, list this matter after, we'll say after 10th.
After 10th.
Hello.
List this matter.
Specific date, my lord. Specific date.
List this matter after 4 weeks, so as to enable the learned counsel for the petitioner to file appropriate applications of the affidavit. Appropriate application of the affidavit. List of.
My lord, interim order to continue till the next date.
List on which date?
My lord, any date after 10th.
16 is.
Not during the puja vacation, my lord, not during the puja vacations.
16.
My lord.
16/10/2023.
My lord, or the
Interim-
interim order.
Interim order passed earlier shall continue.
Highly obliged. Highly obliged. Hello.
Stop the streaming.